May be seated.
All right, welcome back, members of the jury. Hope you've had a pleasant weekend. We got nice weather. Hope you got to enjoy a little bit outside. As I mentioned to you on Friday, you've heard all the evidence that you will hear in the guilt innocence portion of this trial. Now I am going to read to you the law through this document, which I'm holding before you. It's entitled Charge of the Court. It's a lengthy document. It's got 45 substantive pages for me to read. I need to read this document in its entirety. When I'm done reading it, each side will have an opportunity to have closing arguments. Now, this morning will be a little long, and so if you need a break, don't hesitate to stop. There will be stops between my reading and each side going, so there will be those opportunities. But if you need a break, you let me know. Hopefully you're able to make those phone calls, because you do know that once I start reading this, then you are officially in a situation where you cannot communicate with anybody. So I hope you did all that this morning. I did instruct the deputy to let y'all know that. We do anticipate obtaining lunch for y'all during the lunch hour, so you should be okay there. All right. Charge of the court. Members of the jury. The defendant, Alfred Flores, stands charged by indictment in cause number 2023 CR 11510A. In count 1 of the indictment in cause number 2023 CR 11510A, Alfred Flores is charged with the offense of murder. In counts 2 and 3 of the indictment in cause number 2023 CR 11510A, Alfred Flores is charged with the offense of aggravated assault. In count 4 of the indictment in cause number 2023 CR 11510A, Alfred Flores is charged with the offense of deadly conduct. All of these offenses alleged against Alfred Flores in cause number 2023 CR 11510A are alleged to have been committed on or about the 23rd day of June 2023 in Bexar County, Texas. To all of these charges, Alfred Flores has pleaded not guilty. The defendant, Eleazar Alejandro, stands charged by indictment in cause number 2023 CR 11510B. In count 1 of the indictment in cause number 2023 CR 11510B, Eleazar Alejandro is charged with the offense of murder. In counts 2 and 3 of the indictment in cause number 2023 CR 11510B, Eleazar Alejandro is charged with the offense of aggravated assault. In count 4 of the indictment in cause number 2023 CR 11510B, Eleazar Alejandro is charged with the offense of deadly conduct. All of these offenses alleged against Eleazar Alejandro in cause number 2023 CR 11510B are alleged to have been committed on or about the 23rd day of June 2023 in Bexar County, Texas. To all of these charges, Eleazar Alejandro has pleaded not guilty. The defendant, Nathaniel Villalobos, stands charged by indictment in cause number 2023 CR 11510C. In count 1 of the indictment in cause number 2023 CR 11510C, Nathaniel Villalobos is charged with the offense of aggravated assault. In count 2 of the indictment in cause number 2023 CR 11510C, Nathaniel Villalobos is charged with the offense of deadly conduct. Both of these offenses alleged against Nathaniel Villalobos in cause number 2023 CR 11510C are alleged to have been committed on or about the 23rd day of June 2023 in Bexar County, Texas. To both of these charges, Nathaniel Villalobos has pleaded not guilty. Applicable statutes and definitions regarding the charged offenses. Number 1, murder. A person commits the offense of murder under Texas Penal Code section 19.02b if the person intentionally or knowingly causes the death of an individual or intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. 2, assault. A person commits the offense of assault under Texas Penal Code section 22.01a if the person intentionally, knowingly, or recklessly causes bodily injury to another or intentionally or knowingly threatens another with imminent bodily injury. Number 3, aggravated assault. A person commits the offense of aggravated assault under Texas Penal Code section 22.02a if the person commits an assault as defined in paragraph 2 and the person causes serious bodily injury to another or uses or exhibits a deadly weapon during the commission of the assault. Number 4, deadly conduct. A person commits the offense of deadly conduct under Texas Penal Code Section 22.05b if the person knowingly discharges a firearm at or in the direction of one or more individuals. Number 5, actor means a person whose criminal responsibility is an issue in a criminal case. Another means a person other than the actor. Bodily injury means physical pain, illness, or any impairment of physical condition. Conduct means an act or omission and its accompanying mental state. A deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Element of offense means A, the forbidden conduct, B, the required culpability, and C, any required result. Individual means a human being who is alive. Peace officer means a person elected, employed, or appointed as a peace officer. The following are peace officers: a sheriff, a deputy for the sheriff, a police officer of a municipality. Public servant means a person elected, selected, appointed, employed, or otherwise designed or designated as an officer, employee, or agent of government. Serious bodily injury means a bodily injury that creates a substantial risk of death, or that causes death, serious permanent disfigurement, or protracted loss or use of impairment of the function of any bodily member or organ. A person acts intentionally or with intent with respect to the result of his conduct when it is his conscious objective or desire to cause the result. A person acts intentionally or with intent with respect to the nature of his conduct when it is his conscious objective or desire to engage in the conduct. A person acts knowingly or with knowledge with respect to the result of his conduct when he is aware that his conduct is reasonably certain to cause a result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. A person acts recklessly or is reckless with respect to the circumstances surrounding his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. Number 7, you are instructed that the use of deadly force to intentionally prevent or obstruct a peace officer from effecting an arrest is a use of unlawful deadly force. You are therefore instructed to disregard and not consider for any purpose any evidence presented and any arguments made that Melissa Perez had any justification whatsoever for using force or deadly force if she was. To this regard, and as previously instructed, you are instructed to disregard all questions asked by the state and any testimony elicited in response related to the suggestion that the complainant, Melissa Perez, had a justification for her conduct under Chapter 9 of the Texas Penal Code. You are instructed that she did not. Melissa Perez did not have the legal right to resist the defendant's attempts to arrest her. This is not an issue in this case, and you are to disregard all testimony, evidence, questions, and arguments related to that issue. Justification defenses. Number 8, use of deadly force in self-defense and use of deadly force in defense of a third person. It is a defense to prosecution that the conduct in question was justified under the law. A person is justified in using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of unlawful force. A person is justified in using deadly force against another, number 1, if the actor would be justified in using force against the other as described above, and number 2, when and to the degree the actor reasonably believes the deadly force is immediately necessary to protect the actor against the other's use or attempted use of unlawful deadly force. A person is justified in using deadly force against another to protect a third person if, number 1, under the circumstances as the actor reasonably believes them to be, the actor would be justified under the law of self-defense as described above in using deadly force to protect himself against the unlawful deadly force he reasonably believes to be threatening the third person he seeks to protect. And, number 2, the actor reasonably believes that his intervention is immediately necessary to protect the third person. Reasonable belief means a belief that would be held by an ordinary and prudent man in the same circumstances as a defendant. Deadly force means force that is intended or known by the person using it to cause, or in the manner of its use or intended use, is capable of causing death or serious bodily injury. A person has a right to defend himself and others from apparent danger to the same extent as he would have had the danger been real, provided he acted upon a reasonable apprehension of danger as it appeared to him from his standpoint at the time. You are instructed that in determining whether a defendant reasonably believed that the use of deadly force was necessary, the jury may not consider whether the defendant failed to retreat. A defendant is not required to prove that he was justified under the law of self-defense in defense of a third person. The state must prove beyond a reasonable doubt that the defendant's conduct was not justified under the laws of self-defense and defense of a third person. Number 9, application of justification defenses. Now, keeping in mind all the instructions given in paragraph 8, even if you unanimously find that the state has proven beyond a reasonable doubt that the named defendant committed the offense charged in the indictment in this cause, you must next decide whether the state has also proven beyond a reasonable doubt that the conduct of the defendant was not justified under the laws described above. Therefore, if you find from the evidence beyond a reasonable doubt that the named defendant in this cause committed the charged offense as set out and instructed herein, but you further find from the evidence that, or you have a reasonable doubt as to whether at the time he did so, number 1, the defendant reasonably believed, as viewed from the standpoint that Melissa Perez was using or attempting to use unlawful deadly force against the defendant, or the defendant reasonably believed, as viewed from the standpoint that Melissa Perez was using or attempting to use unlawful deadly force against a third person, and the defendant's intervention was immediately necessary to protect the third person, and, number 2, the defendant reasonably believed, as viewed from his standpoint, that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Melissa Perez's use or attempted use of unlawful deadly force, or the defendant reasonably believed, as viewed from the standpoint that his intervention and use of deadly force and the degree of deadly force used were immediately necessary to protect the third person against Melissa Perez's use or attempted use of unlawful deadly force. Then you will find in favor of the defendant on his claim that his conduct was justified, and you will therefore find that the state has failed to prove beyond a reasonable doubt that the defendant was justified under the law of self-defense and defense of a third person as instructed herein, and you will therefore find the defendant not guilty of the charged offense. However, if you find from the evidence beyond a reasonable doubt that the named defendant in this cause committed the charged offense as set out and instructed herein, and you further find from the evidence beyond a reasonable doubt that, number 1, the defendant did reasonably believe that Melissa Perez was using or attempting to use unlawful deadly force against the defendant, and the defendant did not reasonably believe that Melissa Perez was using or attempting to use unlawful deadly force against a third person, or even if Melissa Perez was using or attempted to use unlawful deadly force against a third person, the defendant did not reasonably believe that his intervention was immediately necessary to protect the third party, or number 2, the defendant did not reasonably believe that his use of deadly force and the degree of deadly force used were immediately necessary to protect himself against Melissa Perez's use or attempted use of unlawful deadly force, and the defendant did not reasonably believe that his intervention and use of deadly force and the degree of deadly force used were immediately necessary to protect the third person against Melissa Perez's use or attempted use of unlawful deadly force. Then you will find against the defendant on his claim that his conduct was justified, and thus you will find that the state has proven beyond a reasonable doubt that the defendant's conduct was not justified under the law of self-defense and defense of a third person as instructed herein. Therefore, if you unanimously find that the state has proven beyond a reasonable doubt all of the elements in the charged offense as instructed herein, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant was not justified under the law of self-defense and defense of a third person as instructed herein, then you will find the defendant guilty of that charged offense. Number 10. As previously instructed during this trial, you heard questions, testimony, and arguments throughout this trial regarding the issue of whether the defendant officers were required to obtain an arrest warrant before entering Melissa Perez's apartment in an attempt to place her under arrest. As a general matter, whether or not police officers are permitted to enter a person's residence to make an arrest without first obtaining an arrest warrant is a legal issue for the court to address and not a matter for the jury to decide. In this case, whether or not the 3 defendants in these cases were required to obtain an arrest warrant on the night in question before attempting to enter Melissa Perez's apartment to place her under arrest is not an issue for the jury to decide in these cases, and all such evidence pertaining to that issue is irrelevant and not to be considered by you for any purpose. You are instructed to disregard all questions, testimony, and evidence related to the subject of whether these three defendants were obligated to obtain a warrant before attempting to arrest Melissa Perez. Cause number 2023 CR 11510A, Alfred Perez. Number 11. Cause number 2023 CR 11510A, Alfred Perez, count 1, murder. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023 in Bexar County, Texas, the defendant Alfred Flores, with intent to cause serious bodily injury to an individual, namely Melissa Perez, did commit an act clearly dangerous to human life that caused the death of Melissa Perez by shooting Melissa Perez with a deadly weapon, namely a firearm, or the defendant Alfred Flores had intentionally or knowingly caused the death of an individual, namely Melissa Perez, by shooting Melissa Perez with a deadly weapon, namely a firearm, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Alfred Flores was not justified under the law of self-defense as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Alfred Flores was not justified under the law of self-defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant Alfred Flores guilty of the offense of murder and charge in count 1 of the indictment in cause number 2023 CR 11510A. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant Alfred Flores not guilty of count 1. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of murder as instructed above, or you have a reasonable doubt as to whether the state has met its burden to prove beyond a reasonable doubt all of the elements of murder as charged in count 1, or if you find that the state has not proven beyond a reasonable doubt that Alfred Flores was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Alfred Flores was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Alfred Flores was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Alfred Flores was justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant Alfred Flores not guilty of the offense of murder as charged in count 1 of the indictment in cause number 2023 CR 11510A. Number 12. Cause number 2023 CR 11510A, Alfred Flores, count 2, aggravated assault. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023 in Bexar County, Texas, the defendant Alfred Flores did use or exhibit a deadly weapon, namely a firearm, and Alfred Flores had intentionally, knowingly, or recklessly caused bodily injury to Melissa Perez by shooting Melissa Perez with said deadly weapon, and Alfred Flores was then and there a public servant acting under color of his employment, namely a San Antonio police officer, or the defendant Alfred Flores had intentionally, knowingly, or recklessly caused bodily injury to Melissa Perez by shooting a projectile at or in the direction of Melissa Perez, thereby causing serious bodily injury to Melissa Perez, and Alfred Flores was in and there a public servant acting under color of his employment, namely a San Antonio police officer, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Alfred Flores was not justified under the law of self-defense as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Alfred Flores was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant Alfred Flores guilty of the offense of aggravated assault as charged in count 2 of the indictment and in cause number 2023 CR 11510A. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant Alfred Flores not guilty of count 2. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of aggravated assault as instructed above, or you have a reasonable doubt as to whether the state has met its burden to prove beyond a reasonable doubt all of the elements of aggravated assault in count 2, or if you find that the state has not proven beyond a reasonable doubt that Alfred Flores was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you have a reasonable doubt as to whether Alfred Flores was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Alfred Flores was not justified under the law of defense of a third person, as instructed in paragraphs 8 and 9, or if you have a reasonable doubt as to whether Alfred Flores was justified under the law of defense of a third person, as instructed in paragraphs 8 and 9, then you will find the defendant, Alfred Flores, not guilty of the offense of aggravated assault as charged in count 2 of the indictment in cause number 2023 CR 11510A. Number 13, cause number 2023 CR 11510A, Alfred Flores, count 3, aggravated assault. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023 in Bexar County, Texas, the defendant, Alfred Flores, did use or exhibit a deadly weapon, namely a firearm, and Alfred Flores had intentionally or knowingly threatened imminent bodily injury to Melissa Perez by shooting at or in the direction of Melissa Perez with said deadly weapon, and Alfred Flores was in and there a public servant acting under color of employment, namely a San Antonio police officer, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Alfred Flores, was not justified under the law of self-defense as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Alfred Flores, was not justified under the law of defense of a third person, as instructed in paragraphs 8 and 9, then you will find the defendant, Alfred Flores, guilty of the offense of aggravated assault as charged in count 3 of the indictment in cause number 2023 CR 11510A. If you do not so find or you have a reasonable doubt thereof, you will find the defendant, Alfred Flores, not guilty of count 3. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of aggravated assault as instructed above, or you have a reasonable doubt as to whether the state has met its burden to prove beyond a reasonable doubt all of the elements of aggravated assault as charged in count 3, or if you find that the state has not proven under a reasonable doubt that Alfred Flores was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Alfred Flores was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Alfred Flores was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Alfred Flores was justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant, Alfred Flores, not guilty of the offense of aggravated assault as charged in count 3 of the indictment in cause number 2023 CR 11510A. Number 14, cause number 2023 CR 11510A, Alfred Flores, count 4, deadly conduct. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023 in Bexar County, Texas, the defendant, Alfred Flores, had knowingly discharged a firearm at or in the direction of an individual, namely Melissa Perez, and Alfred Flores was in and there a public servant acting under color of his employment, namely a San Antonio police officer, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Alfred Flores, was not justified under the law of self-defense as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Alfred Flores, was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant, Alfred Flores, guilty of the offense of deadly conduct as charged in count 4 of the indictment in cause number 2023 CR 11510A. If you do not so find or have a reasonable doubt thereof, you will find the defendant, Alfred Flores, not guilty of count 4. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of deadly conduct as instructed above, or you have a reasonable doubt as to whether the state has met its burden to prove beyond a reasonable doubt all of the elements of deadly conduct as charged in count 4, or if you find that the state has not proven beyond a reasonable doubt that Alfred Flores was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Alfred Flores was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Alfred Flores was not justified under the law of self-defense of a third person as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Alfred Flores was justified under the law of defense of a third person as instructed in paragraphs 8 and 9, you will find the defendant, Alfred Flores, not guilty of the offense of deadly conduct in count 4 of the indictment in cause number 2023 CR 11510A. Do y'all need to find accommodations?
Yes, Judge.
Okay. Let's go ahead and take a short little break and let's go ahead and get them accommodations. No, let's go ahead and keep the jury here. You just want to, maybe some folks can sit up front up here.
Can y'all scoot in as much as y'all can? You gotta squeeze in because the space is limited.
We just want to make sure everybody that wants to be here, they have a right to be here, so we make room for them.
Right here.
All right, let me get back to it, members of the jury. I'm on page 26, moving along. Cause number 2023 CR 11510B, Eleazar Alejandro. Number 15, cause number 2023 CR 11510B, Eleazar Alejandro, count 1, murder. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023 in Bexar County, Texas, the defendant, Eleazar Alejandro, with intent to cause serious bodily injury to an individual, namely Melissa Perez, did commit an act clearly dangerous to human life that caused the death of Melissa Perez by shooting Melissa Perez with a deadly weapon, namely a firearm, or the defendant, Eleazar Alejandro, did intentionally or knowingly cause the death of an individual, namely Melissa Perez, by shooting Melissa Perez with a deadly weapon, namely a firearm, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Eleazar Alejandro, was not justified under the law of self-defense as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Eleazar Alejandro, was not justified under the law of defense of a third person, as instructed in paragraphs 8 and 9, then you will find the defendant, Eleazar Alejandro, guilty of the offense of murder as charged in count 1 of the indictment in cause number 2023 CR 11510B. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant, Eleazar Alejandro, not guilty of count 1. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of murder as instructed above, or you have a reasonable doubt as to whether the state has met its burden to prove beyond a reasonable doubt all of the elements of murder as charged in count 1, or if you find that the state has not proven beyond a reasonable doubt that Eleazar Alejandro was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Eleazar Alejandro was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Eleazar Alejandro was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Eleazar Alejandro was justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant, Eleazar Alejandro, not guilty of the offense of murder as charged in count 1 of the indictment in cause number 2023 CR 11510B. Number 16, cause number 2023 CR 11510B, Eleazar Alejandro, count 2, aggravated assault. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023 in Bexar County, Texas, the defendant, Eleazar Alejandro, did use or exhibit a deadly weapon, namely a firearm, and Eleazar Alejandro did intentionally, knowingly, or recklessly cause bodily injury to Melissa Perez by shooting Melissa Perez with said deadly weapon, and Eleazar Alejandro was then and there a public servant acting under color of his employment, namely a San Antonio police officer, or the defendant, Eleazar Alejandro, did intentionally, knowingly, or recklessly cause bodily injury to Melissa Perez by shooting a projectile at or in the direction of Melissa Perez thereby causing serious bodily injury to Melissa Perez, and Eleazar Alejandro was in and there a public servant, acting under color of his employment, namely a San Antonio police officer, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Eleazar Alejandro was not justified under the law of self-defense as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Eleazar Alejandro was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant Eleazar Alejandro guilty of the offense of aggravated assault as charged in count 2 of the indictment in cause number 2023 CR 11510B. If you do not so find, or you have a reasonable doubt thereof, you will find the defendant Eleazar Alejandro not guilty of count 2. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of aggravated assault as instructed above, or you have a reasonable doubt as to whether the state has met its burden to prove beyond a reasonable doubt all of the elements of aggravated assault as charged in count 2, or if you find that the state has not proven beyond a reasonable doubt that Eleazar Alejandro was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Eleazar Alejandro was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Eleazar Alejandro was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Eleazar Alejandro was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant Eleazar Alejandro not guilty of the offense of aggravated assault as charged in count 2 of the indictment in cause number 2023 CR 11510B. Number 17, cause number 2023 CR 11510B, Eleazar Alejandro, count 3, aggravated assault. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023, in Bexar County, Texas, a defendant, Eleazar Alejandro, did use or exhibit a deadly weapon, namely a firearm, and Eleazar Alejandro did intentionally or knowingly threaten imminent bodily injury to Melissa Perez by shooting at or in the direction of Melissa Perez with said deadly weapon, and Eleazar Alejandro was in and there a public servant acting under color of his employment, namely a San Antonio police officer, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Eleazar Alejandro, was not justified under the law of self-defense as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Eleazar Alejandro, was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant, Eleazar Alejandro, guilty of the offense of aggravated assault as charged in count 3 of the indictment in cause number 2023 CR 11510B. If you do not so find, or you have a reasonable doubt thereof, you will find the defendant Eleazar Alejandro not guilty of cause 3. And count number 3. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of aggravated assault as instructed above, or you have a reasonable doubt as to whether the state has met its burden to prove beyond a reasonable doubt all of the elements of aggravated assault as charged in count 3, or if you find that the state has not proven beyond a reasonable doubt that Eleazar Alejandro was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Eleazar Alejandro was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Eleazar Alejandro was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Eleazar Alejandro was justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant Eleazar Alejandro not guilty of the offense of aggravated assault as charged in count 3 of the indictment and cause number 2023 CR 11510B. Number 18, cause number 2023 CR 11510B, Eleazar Alejandro, count 4, deadly conduct. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023, in Bexar County, Texas, the defendant Eleazar Alejandro did knowingly discharge a firearm at or in the direction of an individual, namely Melissa Perez, and Eleazar Alejandro was then and there a public servant acting under color of his employment, namely a San Antonio police officer, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Eleazar Alejandro was not justified under the law of self-defense as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Eleazar Alejandro was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant Eleazar Alejandro guilty of the offense of deadly conduct as charged in count 4 of the indictment in cause number 2023 CR 11510B. If you do not so find or you have a reasonable doubt thereof, you will find the defendant Eleazar Alejandro not guilty of count 4. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of deadly conduct as instructed above, or you have a reasonable doubt as to whether the state has met its burden to prove beyond a reasonable doubt all of the elements of deadly conduct as charged in count 4, or if you find that the state has not proven beyond a reasonable doubt that Eleazar Alejandro was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you have a reasonable doubt as to whether Eleazar Alejandro was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Eleazar Alejandro was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Eleazar Alejandro was justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant Eleazar Alejandro not guilty of the offense of deadly conduct as charged in count 4 of the indictment in cause number 2023 CR 11510B. Cause number 2023 CR 11510C, Nathaniel Villalobos. Number 19, cause number 2023 CR 1151C, Nathaniel Villalobos, count 1, aggravated assault. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023 in Bexar County, Texas, the defendant, Nathaniel Villalobos, did use or exhibit a deadly weapon, namely a firearm, and Nathaniel Villalobos did intentionally or knowingly threaten imminent bodily injury to Melissa Perez by shooting at or in the direction of Melissa Perez with said deadly weapon. And Nathaniel Villalobos was then and there a public servant acting under color of his employment, namely a San Antonio police officer. And if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Nathaniel Villalobos was not justified under the law of self-defense, as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant Nathaniel Villalobos was not justified under the law of defense of a third person, as instructed in paragraphs 8 and 9, then you will find the defendant Nathaniel Villalobos guilty of the offense of aggravated assault as charged in count 1 of the indictment in cause number 2023 CR 11510C. If you do not so find, or you have a reasonable doubt thereof, you will find the defendant Nathaniel Villalobos not guilty of count 1. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of aggravated assault as instructed above, or you have a reasonable doubt as to whether the state has met its burden by proof beyond a reasonable doubt all of the elements of aggravated assault as charged in count 1, or if you find that the state has not proven beyond a reasonable doubt that Nathaniel Villalobos was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Nathaniel Villalobos was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Nathaniel Villalobos was not justified under the law of self-defense of a third person, as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Nathaniel Villalobos was justified under the law of defense of a third person, as instructed in paragraphs 8 and 9, then you will find the defendant Nathaniel Villalobos not guilty of the offense of aggravated assault as charged in count 1 of the indictment in cause number 2023 CR 11510C. Number 20, cause number 2023 CR 11510C, Nathaniel Villalobos, count 2, deadly conduct. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 23rd day of June 2023 in Bexar County, Texas, the defendant, Nathaniel Villalobos, did knowingly discharge a firearm at or in the direction of an individual, namely Melissa Perez, and Nathaniel Villalobos was in there a public servant acting under color of his employment, namely a San Antonio police officer, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Nathaniel Villalobos, was not justified under the law of self-defense as instructed in paragraphs 8 and 9, and if you unanimously find that the state has proven beyond a reasonable doubt that the defendant, Nathaniel Villalobos, was not justified under the law of defense of a third person as instructed in paragraphs 8 and 9, then you will find the defendant, Nathaniel Villalobos, guilty of the offense of deadly conduct as charged in count 2 of the indictment in cause number 2023 CR 11510C. If you do not so find, or if you have a reasonable doubt thereof, you will find the defendant, Nathaniel Villalobos, not guilty of count 2. In other words, if you find that the state has not proven beyond a reasonable doubt the elements of the offense of deadly conduct as instructed above, or you have a reasonable doubt as to whether the state has met its burden to prove beyond a reasonable doubt all of the elements of deadly conduct as charged in count 2, or if you find that the state has not proven beyond a reasonable doubt that Nathaniel Villalobos was not justified under the law of self-defense as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Nathaniel Villalobos was justified under the law of self-defense as instructed in paragraphs 8 and 9, or if you find that the state has not proven beyond a reasonable doubt that Nathaniel Villalobos was not justified under the law of defense of a third person, as instructed in paragraphs 8 and 9, or you have a reasonable doubt as to whether Nathaniel Villalobos was justified under the law of defense of a third person, as instructed in paragraphs 8 and 9, then you will find the defendant, Nathaniel Villalobos, not guilty of the offense of deadly conduct as charged in count 2 of the indictment in cause number 2023 CR 11510C. Number 21. Our law provides that a defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded a defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. As it applies to each case, if the defendant in that case has elected not to testify, you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by means about these cases. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone any information or receive any information from anyone about these cases, or to conduct any research about these cases until I accept your verdicts. Written statements made by a witness or police reports made by officers and tendered by the attorneys of opposing counsel for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times statements and reports may be marked with an exhibit number but are neither offered nor received in evidence. Therefore, I can send only statements and reports received in evidence to the jury room. The grand jury indictment is not evidence of guilt. It is a means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether a defendant is guilty or not guilty. During your deliberations in these cases, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with these cases which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching your verdicts in these cases. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with an offense, gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence to produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless all 12 jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in each case. The prosecution has a burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt, and by disproving any and all justification defenses beyond a reasonable doubt, and if it fails to do so, you must acquit that defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning a defendant's guilt. In the event you have a reasonable doubt as to a defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but the law of these cases you must receive from the court is contained in these instructions and be governed thereby. You must disregard any comment or statement made by the court during the trial, or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication was intended. After argument at counsel, you will retire to the jury room, select your own foreperson, and proceed with your deliberations. After you have reached a unanimous verdict to each case, which means all 12 of you must agree, the foreperson will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as foreperson. The forms are not intended to suggest to you what your verdict should be. Your sole duty at this time is to determine whether each defendant is guilty or not guilty under the indictments in these causes, and restrict your deliberations of the issue of whether each defendant is guilty or not guilty and nothing else. If the jury wishes to communicate with the court, they shall notify the bailiff. Any and all communication related to these cases must be written, prepared by the foreperson, and submitted to the court through the deputy. Respectfully submitted, Judge Ron Rangel, 379th Judicial District, Bexar County, Texas. And on the back of that charge is a separate verdict form for each defendant, and each defendant has separate counts. There's a verdict form for each count for each defendant. Now, before we begin with closing argument, does anybody require a break on the jury? All right, let's go ahead and take a super short break. We'll be ready when you are.
All right, for the jury.
May be seated.
All right, welcome back, members of the jury. Now, the attorneys are going to have an opportunity. They tell me they may not take this long, but they'll have an opportunity to speak to in total for 3.5 hours. So we're going to take a break whenever you need a break. So you just raise your hand and we'll give you a break at that time. All right. State, are you ready to begin your closing argument?
Yes, Your Honor.
All right, you may proceed.
Thank you, Your Honor. May it please the court, members of council. Good morning to all of you. 10th of November, 30 days to the day that we stood here that Friday afternoon and we opened. I'd like to just have an abundance of caution, if anything. Myself, Mr. Lunan, Mr. Escobar, said or did you found wrong and inappropriate, we sincerely apologize. Nothing was ever intended. It may have been a comment in the heat of argument. I'd also like to take an opportunity to say briefly what this trial has not been about. I believe I'm the only member of the attorneys that has actually worn our nation's uniform and served on active duty, which I did so for 4 years at the military academy and 20 years in the Army. I followed that up with 23 years here in this office, serving the community that I moved my family to. Myself, Mr. Lunan, Mr. Escobar, we understand and honor the commitment anyone makes to serve their community and country. This is not an attack on law enforcement and those who have made that commitment. This is one incident in time being adjudicated and resolved by you all, the citizens of Bexar County. I'd like to begin my remarks by going back to jury selection day. In that basement, the first floor courtroom of 399, where you all sat with 187 other your best friends. I remember Mr. Goss, he read a quote attributed to Thomas Jefferson, our third president, one would say maybe the architect of our system of laws. He said that I consider trial by jury as the only anchor imagined by man by which a government can be held to the principles of its constitution. Lofty words. I think what then President Jefferson meant is that citizens, you all, serving as jurors, you serve as the safety net to keep the government from becoming tyrannical, oppressive. I find that perspective particularly appropriate for this trial because at 2:02 a.m. Friday morning, June 23rd, 2023, at the Rosemont at the Mills Apartments, 3102, these defendants were all members of the government. These three and their 12 other associates, they were all members of the government, serving as officers, where the norm is that officers interacting with the public obligated to carry out and serve the letter, but also the spirit and the intent of the law. So it is appropriate that you, the citizens of Bexar County, hear the evidence, review the facts, consider the law, and render your decision. That's all this has been about. As a way of review, I would like to consider elements of States Exhibits 5, State 6, State 7, and States 8. These are videos of the first 3 responding officers. Selected portions. Rojas, Ramos, Salinas. It's already in evidence, but it sets the context for what happened.
From that side of America.
So what happened, man? What happened
With what?
with the box in there?
What do you want me to tell you?
Your dog?
You told us?
Yeah.
Who you are?
Yeah.
What do you want me to tell you? The anger.
So what happened?
See, once I cut them wires off, there's a lot of audio that went. And then, you don't believe me, I can show you some stuff.
There's a lot of what?
I can show you some evidence. Evidence of what I'm investigating.
What are you investigating?
What am I investigating? What I'm investigating is the harassment of people.
Okay.
The audios, the way they make people sound,
Okay.
the way they make them seem crazy. That's what I'm investigating.
Okay.
Because I've been a victim myself. And when I tell you I can show you evidence, it's because I got shit on evidence. Come here, baby girl.
Are you diagnosed with any mental illnesses?
No, don't disrespect me.
I'm not disrespecting. I'm making you a
But
question.
see, this is my
Are you
paper.
diagnosed with any mental illnesses?
No.
No?
There's been me diagnosed with schizophrenia, but I'm not schizophrenic.
Okay.
I'm
You
more
are diagnosed with
intelligent. No.
it? Now you are.
I was diagnosed by a falsification psychiatrist.
Do you take medication for it?
No, I don't.
No. Are you prescribed medication for it?
No.
No.
And see, when you tell me things like that, I get offended. Because my knowledge is mentality is very straight. And that's why I get offended when somebody comes and tells me, do you got mental problems? I ain't got no mental problems.
What's your name?
Everybody knows my name, but
I don't know your
it's
name. That's what I'm asking. What's your name?
Melissa Perez.
What's your date of birth?
12177.
What apartment you live in?
3102.
Who you live there with?
I live by myself, my dog, and a gentleman that lives with me that I picked up from the street.
Okay. Just a friend or what?
He's a friend that I picked up who needed help, medical attention.
Okay. So why did you cut the wires?
Why not? Did it turn anything off?
Yeah, the alarm. That's why they're here.
The alarm. They knows and they're watching me. They see the
Let's walk
wire.
over to my car real quick, okay? Come on.
Come on, baby girl.
Right here.
Right here?
Yeah. Right here. Just stand right here in front of the car, okay?
Are you gonna arrest me?
No. Just stand right here in front of the car. Nah. Hey. Melissa. Come get your dog. Alright. Okay, well come get him. Alright, Melissa, come here. Let me run real quick. So this girl put all this stuff over here. When I got here, she was fire, right? So she was she come put all these wires over here. So when I got here, she was over here with fire. And she was talking to him. After I talked to her, she's all like, well, FBI, this and that. I'm like, all right, well, come walk with me over here to my car. I think so, yeah. So she put all these wires. So all the fire alarm,
Came out.
Nah.
So fire said it's in the apartment complex, not theirs. So tampering with fire alarm.
Up there, right? Yeah. She's there, she's won't come out.
She's right here.
Are you joking?
I don't know you.
Yeah, she is.
No.
She was signed
I said,
by
what's your
FBI.
name?
I was in there pretty near.
No, I don't know your
I was
name.
in runner. And
No, he asked you your name.
he got there.
I wasn't here. I'm trying to figure out what's your name. And that they want to push it for a cussing. And they call Flores. Ma'am, I don't know your name. Yeah, it sounds like that's me.
Yeah, that's what I was doing. I was thinking just trying to hear her. And let's get her on that. But it's already. What do you say?
Last time I told you she was on that curve over there.
And I was gonna get the thing that I didn't jump it. I was gonna jump on that thing and I was like, man.
No, I paid attention. I was like,
I couldn't see, it was dark. I just came running like that. I was like, jump out. Man, thank God I didn't jump out. Fucking my shit up.
let me call Dark real quick. More likely she's the SB. No, she comes out with the truck.
Yeah, bro. So,
Gotta have fun.
I was like, what the hell? That's all I think of.
That mine's bigger.
That's what I think to it. Yeah.
All in there. Are you talking to yourself now? But there's no one inside that apartment. Prove it. Show me.
This thing I set up for now.
Do you hear voices in your head, man? Are the voices talking to you?
So she got mad. I mean, mad because I was like, just talking about FBI and all that, and I was like, so I asked her, are you diagnosed with any mental illnesses? And she goes, no, I get offended when people ask me that. I go, I'm just asking, do you take medication? No. Or you prescribing medication? No, I get offended when people ask me, I'm not crazy. I'm like, yeah, I'm just asking you a couple of questions. That's why I told her, hey, come over here and come and walk with me. A what?
So that right press you pulled up like right.
Oh, yeah, I know that.
It was like driving like fast, like through the complex. I thought it was stolen.
Okay, come back to Gillette for a moment. 242 Gillette. 242 Gillette. Complaint says AirTag was connected to her phone.
I'm already diagnosed with any
And
mental
you
illness.
was following her.
Take any medication for mental illness? Are you schizophrenic? Bipolar? You hear voices in your head?
What's up? We're good. Hey, bro. We're good. Come on.
She's still on the couch? She's still on the couch? Leandro said we could go get her. He said we could go get her to the screen door.
Go in there and get it? Bro?
Yeah.
Who's this guy?
Flores? Yeah. Told him. He said, okay. Just gave me his badge number. Okay. That's not good. The doors, it's like right about. You want to keep them? You're good. That's all you do. You get one shot, get one shot. I'll go from there. I'll stretch first.
I believe it important to review how the members of the government, and they're all members of the government, interacted with citizen Melissa Perez. That was an hour after initial arrival. There were some other observations I made. Melissa Perez was an open book. She told you who she was, where she lived, did not disrespect Officer Rojas. She told you what her conditions and afflictions were, that when she cut the alarms, it was much quieter. Something else also brought out as you heard the evidence. You saw when she raised her arm up, the band around her arm. When questioned from Daisy, her sister, how she made her living, said she sold blood, she walked miles She did what she had to do. And yet still opened her home to somebody that had less than her. That's who your government interacted with over an hour. Did you see, I believe the quote was, a goal-oriented assailant? A hardened, rugged roofer who used her tool and weapon of choice, a hammer? Or was it a citizen that needed her government to listen and help her? In state's portion of jury selection, Mr. Lunan laid out the elements for the offense of murder. It is without saying that if you pull that 40 millimeter issued weapon, you point it at a direction, you expend rounds into a home, you never fire at anything you don't intend to destroy or kill. You decide if we've met the elements of that. Assault on a public servant, intentionally or knowingly drawing. You decide if we've met the elements of that and overcoming the justifications and defenses. We've never shied. Yes, the burden rests here. But when you get to your deliberation, you've heard this expression throughout the trial, in the totality of the circumstances. Because the one person that was an open book, that's the only way she can speak. Deadly conduct, a lesser form of the aggravated assault by threats. Again, it is your decision, you, the community, that decides if we meet the burden. I want also to bring up what is also in evidence. Defense Exhibit 23. Defense wanted this in. Examine it when you get back to deliberate. The first part in the discussion. Note, it is this agency, it's not law, but it is the intent, the aim of the government agency the defendants served. Paragraph A. Protection of property, apprehension of offenders is subservient to the protection of life. Yes, their own, obviously, but life of the citizens. Paragraph D. Deadly force used as a last resort. The department places greater value on human life than on protection of property. Or even to effect an arrest. You may recall on cross-examination, Mr. Cifuentes stood here professorially and he read off of paragraph .07. This section applies to all forms of deadly force, regardless of the type of instrument or weapon used. The use of deadly force is authorized only to protect an officer or another person when an officer has a reasonable belief that his or the life reasonable belief is in imminent danger. He is justified to use deadly force. But I find it interesting that he did not read or publish paragraph C. At the point when an officer a government agent should reasonably perceive the potential exists that deadly force may be an outcome of any situation, the officer must use reasonable alternatives if time and opportunities permit. The reasonableness of the action is based on the time available, the opportunity to perform the action, and the facts apparent to the officer prior to the incident. So when these members of the government got there and they started catching up and getting their briefing, what happened? What led to this? How is it Salinas got struck? What happened? Rojas was there. They chose only to go Salinas deep. He was there. They could have inquired, how is it we're at this state right now? You heard defense's expert Martinelli. We questioned him. Why cross over on a frontal assault? She sees you coming. She even stops the government representative Villalobos at the top of the banister. Did they have to proceed? Was the time available to consider other alternatives when they close the distance, which compresses the time, which compels the schizophrenic who's been harassed for an hour? And all of it took place within 15 minutes of their arrival. Who compressed the time? Who closed the distance? Who made the choices? Now, I just wanted, at this point, what we want is to take you back to how we got there once Government Representative Flores, Alejandro, Villalobos acted. Defense is going to come in and make their arguments. Please give them the attention you've given me. That is how our system works. They will make vigorous arguments, I have no doubt. And Mr. Lunin will come back to give you the state's response and analysis. You are the ones who put a check on the government and how it interacts with our citizens. All of our citizens. This is not the end of the argument, but for my time, I thank you for your attention. Your Honor, the state will move to reserve the balance of its time.
Thank you, Your Honor. It's very revealing that the state begins its presentation showing you evidence that we all now know was not known to these three men. I counted 10 minutes on a slide called How We Got Here, showing everything that happened that nobody told them. That's not fair. That's the deception here. The duty of that office isn't to just throw evidence in front of 12 members of this community and say, okay, you decide. Their duty is to do justice. They're the first stop. They're the filter. They're who bring cases to the grand jury. They should know when the evidence isn't there. That duty to seek justice,
Apologies, Counsel.
that's not it. I won't waste your time covering policy because it's not the law, and you know that because it's not in here. If the judge didn't put it in the charge, it's not the law. These officers had a right to go home. We talked about that during jury selection. This charge, everyone else is going to rehash the evidence that they think is important with you, but I want to talk about this charge because it's almost 60 pages, and I think it helps to outline it topically for you. It's very repetitive. You'll see the words reasonable doubt and burden 100 plus times in there. It's important. But these are the categories of that charge that I want you to be aware of. First is the accusations, followed by the definitions that the judge thinks you need to have, application paragraphs, so applying the charges to each defendant, special rules that the judge is giving you, and of course the most important part of that document is the verdict forms at the end. So starting with the accusations. You now know that Alfred Flores has been charged with murder, 2 counts of aggravated assault, and deadly conduct. Eleazar Alejandro, the government accuses him of murder, 2 counts of aggravated assault, and deadly conduct. And of course, Nathaniel Villalobos, the government is accusing him of aggravated assault and deadly conduct. You'll recall from our presentation a month ago in jury selection, the burden of proof, and just how high it is. Starting at the bottom there with that presumption of innocence. As you go up, not guilty, not guilty, not guilty, not guilty. They have to get to the very top, a single reasonable doubt, and they're not guilty. And it's their burden to eliminate all reasonable doubt. That's their burden. And it can be hard to forget who had the burden in this case because almost all the evidence came from us. The truth came from us. It came from our cross-examination of their witnesses. It came from our offering more evidence, the real context of what these officers actually knew that day. That's their burden, and they didn't get there. And you'll notice this is actually part 1 of their burden. They have to meet it twice in this case, on murder, aggravated assault, and deadly conduct. Now the definitions is the next section of the charge. It's several pages. And it's going to define terms that you've heard over and over again, emphasized over and over again. Murder, aggravated assault, deadly conduct. Bodily injury, deadly weapon. How many times did you hear us define deadly weapon for you? You all don't need it in the charge. You know it by now. Same with serious bodily injury, right? The mental states that the state has to prove. The next section is the first of 2 very important admonitions from the court. You are instructed that the use of deadly force to intentionally prevent or obstruct a peace officer from effecting an arrest is the use of unlawful deadly force. Melissa using a hammer to attack officers trying to arrest her is unlawful deadly force. Period. It's in the charge. You'll remember when Travis Thompson testified, what would the world come to if you could just fight cops trying to arrest you? If that was allowed, he said, everyone would fight you. That's not the law. The second part of their burden is they have to disprove the defenses raised in this case. That's their burden, and the court tells you that. The state must prove beyond a reasonable doubt, again, that the defendant's conduct was not justified. That's their burden. And we have a similar chart that Jason showed you in jury selection. They have to get all the way to the bottom. Not guilty, not guilty, not guilty, not guilty. They have to show they were not justified beyond a reasonable doubt under self-defense or defense of a third person. For murder, aggravated assault, and deadly conduct. It's their burden. Even if, and I don't think you'll get there, but even if you think it's highly unlikely that these men acted in self-defense or defense of each other, it's still a not guilty. I can't say it enough. The court emphasizes you have to unanimously find, and I know I'm being repetitive, the charge is repetitive because that's how important it is. The burden, the burden, the burden. Not just, here you go, you decide. They have to convince you and not just throw it at the wall and see what sticks. That burden, not guilty, not guilty, not guilty. We won't even concede that they've met that initial burden, but let's assume they did. They still have to disprove that self-defense. And what do you know, when we start cross-examining their witnesses and bringing you the evidence, it goes the other way with everything we brought you. And they have to defeat that evidence, and they failed to do so. We're the only ones who brought you an expert to say it was reasonable. It's their burden to show it was not reasonable. A single reasonable doubt is a not guilty. And there's way more than one in this case. The second admonition from the court. It's probably easy to forget because it's been almost a month, but there's a lot of warrant talk early on. No warrant required in this case. You'll see it in the charge. It's not relevant to your decision. Whether or not anyone needed a warrant, they didn't need one. They had a right to arrest her. The next section, and this is really the lion's share of the charge. Of the 60 pages, I think it's 30 pages. It lists each offense for each defendant and each defense that they have to prove beyond a reasonable doubt. And it's, 4 times for Alfred, 4 times for Eleazar, and 2 times for Nathaniel. The offenses and the defenses. The offenses and the defenses. The offenses and the defenses. All of which they have to prove and disprove. Them, not us. The next section, and I want you to pay special attention to this section of the charge. It's special rules. We call them special instructions. The first one is a right all of us in this room have, and that's a right not to testify. It's a right not to testify. We talked about all the reasons. I'm sure you can imagine in this case, it wasn't necessary. The facts are clear here. Nonetheless, you are not to consider that in any way whatsoever. Respect that right. Another important rule, you may have noticed it when the judge read it, a grand jury indictment is not evidence of guilt at all. You may recall some testimony about the burden required to get past a grand jury. The evidence that the state elects to present, good, bad, or indifferent, they pick what to show the grand jury, and that burden is probable cause. Well, we know now what this government, their detective, thinks probable cause is. And he told you himself, nothing changed since grand jury, no new evidence. That right there tells you it's game over. They never got past that low burden of probable cause. Next rule. As Mr. Harris pointed out correctly, this is a tragic case. And we've done our best to be sensitive to Melissa's family and Melissa's memory. But the judge instructs you that you're not to let bias, prejudice, or sympathy play any part in reaching your verdicts in these cases. Okay? So when the government says, honor her memory, we're not trampling on her memory, but you cannot make a decision based on the tragedy itself, okay? We all know now that's not who the police encountered that night. I want her family to remember her this way, but that's not who these men encountered, okay? And it's not fair to hold them responsible for something that they had to do. They had a duty to do, given the circumstances they encountered. The judge reminds you once again, the burden in all criminal cases rests upon them throughout the trial. We don't have to prove our innocence, but we did. Everything we brought you. It's their burden. And I just cannot say it enough. They can't just show you videos and say, you decide. Show you videos, this is sad, she was sick, which they didn't know. You decide. That's not their job. At the very end, you're going to see verdict forms. There's one form for each charge for each defendant. The form starts with the option to find them not guilty. That's the presumption of innocence reflected in that verdict form. We start at not guilty unless and until they prove that they are guilty, which they didn't do in this case. That's the form to get everyone home. Okay? Alfred, Eleazar, and Nathaniel.
Judge, let's go ahead and take a short break. All right.
record.
May be seated.
Before I pass you off to Tom, as you know, we've tried to keep it to the point in this trial. At the end of the instructions, you're going to see the final piece of advice from the court as to how you deliberate. Every jury does it differently. In the many trials we've all been a part of, we always learn different ways that jurors do it. But one thing you have to do is you have to pick your foreperson, whoever that is. So when you get back there, pick your foreperson. That's the leader of the jury. That person will preside over your deliberations, will guide you all. They're also the person that's going to sign those verdict forms and tell the court what your verdict is. When you get back there, you can ask questions, but 99% of the time, the answer will be you have the law and evidence before you. Refer to the charge. I don't frankly think you'll need to. You know in your hearts what you need to do. Send these men home. Send them home. Thank you.
Good morning. When you believe someone, it's as much about promises made as it is about promises kept. And 30 days ago, we were in a hot, crowded room, and you saw two very different presentations of the law, right? You heard a presentation from the state, and then you heard a presentation from the defense. But in effect, what we're doing is we are making you promises. Believe me. Believe the law, believe the facts, believe the story we're about to tell. Promises made, promises kept. And Jason got up and he showed you this exact slide. And he said, you're going to hear about self-defense in this case. That's going to be in the law. That's going to be in the charge. 30 days from now, I'm telling you what's going to be in there. I'm promising you self-defense in that charge. Promises made, promises kept. And he showed you self-defense of a third person. He told you it's going to be in that charge. You have a right in Texas, a right to defend someone if you believe their life is in danger, from real or apparent danger. And you have it in the charge. Promises made, promises kept. He told you about Hamill v. State. He told you about apparent danger. He told you the way the law is written in Texas is very specific, and it gives you the right to act if you reasonably believe the danger is real. Promises made, promises kept. But there's another saying that I want you to keep in mind during deliberations, and it goes like this: fool me once, shame on you. Fool me twice, shame on me. Because when these stories started being told, the government, this is the government, and they told you under 942, their slides were blue, Melissa Perez had a right to defend her home with deadly force against an officer making an arrest. Under 941, she had a right to use force to defend her property in the nighttime. They told you they needed a warrant. They told you there was no exigent circumstances. And then I got up, it was about 8 p.m., and y'all were very gracious with me, and I said, I find it very interesting no one talked about this law right here. Because it literally says you can't do that. And I don't know if you remember that or not. You're looking like you do, so I appreciate you right now. And that was a very long time ago. And you've had a lot of evidence to hear, to tell those stories. And I told you, and I put a sweet picture up of Judge Rangel, remember that? And I said, the judge is going to give you the law at the end of this case. That's what Christian told you, that big packet. He's going to give you the law, what applies, what promises were kept, and what's not in there. And he told you in this trial, you're instructed to disregard any testimony that Melissa Perez was justified. The law, the judge told you, you were instructed she did not. And then you'll see it in the charge. Fool me once, shame on you. Fool me twice, shame on me. And you also heard in the law that testimony and arguments about warrants, about exigency, not relevant, and don't consider it. Fool me once, shame on you. Fool me twice, shame on me. And I'll tell you why that's important. They have the burden. It's very easy to lose that here because the story, the evidence has been told by lawyers that used to be prosecutors, that loved doing this job and left for different reasons. We told you the truth. We promised you the law, and then we delivered it. And all they have promised at this point is nuh-uh. And that's very, very important to realize exactly how dangerous that is. When the government, when the state of Texas, who brings the indictment, who brings the charge, who has the burden to prove it beyond a reasonable doubt, and the burden to disprove justification beyond a reasonable doubt, is reduced to nuh-uh. Is reduced to policies that are not penal code. Is reduced to knowledge that these officers didn't even have. That's dangerous. You want to talk about a check on the government? You want to talk about keeping promises? That's your role here today. Beyond a reasonable doubt never shifts to the defense. Ever. Promises made, promises kept. Now, I promised you another thing in this trial. In that hot evening we spent together in the 399th, I promised you when you turned that spaghetti over, before you served it to your family, when you had to check your heart and check your soul before you were going to serve, take a bite of what this table was going to serve, I promised you a cockroach in the bottom of that pot. And that you would know in the pit of your stomach you could not do it. You know it's not right, and you know they're going to be not guilty. I'm not going to go through the facts all that much. These gentlemen are. I think it was pretty darn clear. But if that's what you're supposed to hang your hat on, that's not fair at all. Promises made, promises kept. We also told you time and distance matter. Christian and I ran around the courtroom with plastic toys for 20 minutes. Never thought you'd see that, right? And we told you over and over again, time and distance matter. Apparently not to Detective Soto. Apparently not to the politically minded individuals who are above him. But time and distance matter. So I can make Alfred's case very, very simple for y'all. You literally got to see him go through the ODA loop in 2 seconds. From 2:02:11 to 2:02:13, once Melissa Perez had been fired on by officers and regained herself in the hall, she was 16 feet away. I did it with a measuring tape, I did it with science. In 16 feet, she took off, traveling 10 feet per second. 6 steps. I know y'all remember it. It's one of the most memorable parts of this trial. 6 steps she made it, going that fast. In a split second, Alfred had to decide. And the testimony proved, not our burden, but it proved he did not fire till the last step. Soto even agreed that's what we want our SAPD officers to do. Alfred did not fire until he was out of time, he was out of distance. The science and the testimony proved that. He has no other choice. It's imminent danger, it's apparent danger. He's reasonably entitled when it's immediate and necessary to the degree of force. That's the law. That's what we promised you. That's what we've proved. And then we showed you this, and we took a moment of silence to look at it because it's staggering. The state wouldn't bring you this. They sure as heck wouldn't want to show it to you because you realize just how close somebody is compared to what you see in those body cams. Alfred had 2 seconds to go through his OODA loop and react. Butch told you everything about that's reasonable. Sergeant Flores, in my opinion, he acted reasonably under the standards of objective reasonableness in this case. And my expert opinion, and nobody's more of an expert than Butch, after reviewing all of the facts and all of the circumstances in this case, I can say with legal certainty he acted appropriately and reasonably when it was immediately necessary to use self-defense to defend himself. It's cut and dry. I have no idea how they would ever get up here. There's no way. But there's more. I never even would have let this case out of my office. You heard from Dr. Martinelli. A very scientific approach that reaches the same place. Reasonable, immediate, necessary, justified. Promises made, promises kept. Now, much of this trial has been about putting yourself in the shoes of the officers, okay? Putting yourself in the place of those officers. And that's the way the law is written, okay? But I believe in fairness. And if I was to put myself in the shoes of Melissa's family, Ms. Nunez, Ms. Tovar, I would feel sad because nothing brings back my loved one. Nothing brings back my mom. Nothing brings back my sister. And I would be sitting through this trial on a hard wooden bench with my stomach in knots. And I would be wondering, what is happening right now? Maybe you'd learn that Rojas and Ramos blew up this call, and maybe you'd be angry about that, and I would be too. Maybe you'd learn that the detective did a terrible job investigating, and I would be angry about that too. Maybe you'd learn that the facts weren't all presented to you 871 days ago, and I would be angry about that too. And maybe you learned that the dignity and legacy of your mom was traded for the personal political agendas of politicians here. And that's not okay either. Because what you were owed is what Lisa told us an investigation should be. Y'all were owed a patient, thorough, and thoughtful investigation. Butch told you you're owed the truth. It's a two-way street. That's what you're owed in this system. That's what's justice. That's what's fair. And so I would like to acknowledge y'all for your poise during this trial. I would be frustrated too. I was born a long way from here. And 20 years ago, I went to law school here in San Antonio. And when I left home, My dad gave me this. Where I come from, this is called an anuksuk. It's a trail marker. And he said, so you can always know the way, so you can always find your way home. And my mom gave me a note. And it said, I shall pass this way but once, and any kindness that I can show to any person, let me do it now, or I shall not pass this way again. Nothing brings their loved one back. And on behalf of Alfred, Eleazar, Nathaniel, and their wives and families, Mitzi, Brittany, and Rachel, we're sorry for your loss. And I'm going to give it to Aurora because I wouldn't presume to hand it directly to you. But I hope y'all find your way home too. I believe the evidence is clear. It's time for everybody to go home here. Thank you.
Ladies and gentlemen, Melissa Perez's death was a tragedy that has to be acknowledged. The state, in their PowerPoint presentation, their video, asked, how did we get here? They showed Officer Rojas in the beginning of the call, and I would like for you to remember his testimony was that he knew from the time that he left the fire sprinkler closet and walked to her that he knew, based upon Lieutenant Chris Hudson's statement, that she was mentally ill, and he had enough information to emergency detain her. And for 2 minutes, he had the ability to arrest her and had the assistance of 3 firefighters, and his cover officer was on the way. So the question, how did we get here? We got here because Officer Rojas, how did he say it? I never got around to it. He told you he didn't do his job. And there were procedures in place where he could have emergency detained Melissa to get her the help that she needed. That's the tragedy, is that Officer Rojas didn't do his job. And as Tom told you, Rojas and Ramos and Salinas failed to tell these gentlemen sitting over here about that mental illness and her need to be emergency detained. So that's how we got here. Now, one of the things that's even more tragic is that SAPD and the DA's office failed to properly investigate this case. And one of the things that folks may have wondered is, why did I introduce the audit trails? The audit trails were important because, if you recall, Detective Soto told you that he submitted his prosecution guide and his chain of command checked off that they reviewed it in August. I asked him, did they pencil whip it? And the fact is they did. And the reason you can know that they pencil whipped it is that if you take a look at the audit trails, the user audit trails for McManus, Karen Fox, the assistant chief, the deputy chief, Captain Van Geffen, Lieutenant Frisky, and Sergeant Galindo Villanueva, that if you look at those audit trails, they didn't look at any videos after he submitted his prosecution guide. they didn't verify what he put in his prosecution guide, and we know that what he put in his prosecution guide was false. He falsely stated that Eleazar Alejandro could not see, and we know that his body camera was here. He stood before you, and I believe it was 42 inches, and that's probably where the railing was, given the 6 inches difference between the ground. So that was among many falsifications in the prosecution guide. Didn't look at Travis Thompson's video until November, a couple of months after the fact. So there's a lot of things that didn't happen, and in fact Van Geffen said that he met with the state and said they were going to get a warrant. But we also heard from Lisa Miller that Ed Pedraza said the decision was already made at 8 o'clock by the chief of police. Now, if you're a juror, would you expect Van Geffen to come testify and say, no, that's wrong? And if he didn't come refute it, you know it's true. And if Chief McManus didn't do that, make a decision at 8 in the morning, you would expect him to come testify that that didn't happen. And we know he was in the crime scene for over a minute, and he didn't submit a report, didn't sign a log, didn't make himself accountable. These officers have to wear body cameras to show what they did, but McManus and Van Geffen and everybody else don't want to be accountable with body cameras or be accountable with their audit trails. So the one thing that's important in this case is that Alfred Flores, Eleazar Alejandro, and Nathaniel Villalobos were justified in what they did. And you know why we know that? Because the DA basically told you so when we heard the testimony from Officer Salinas. And what did Officer Salinas tell you? He told you that he knew that he would have been hit in the head with a hammer, and he'd probably be dead. That Melissa Perez was striking as he was leaning over, and I'm not going to get too close to the jurors, but as he was leaning over, he had his head like this, and Melissa Perez came like this, and when she did, it was right at the same time that Officer Rojas yelled, "Watch out, watch out, watch out, watch out." And had he not heard that warning, he would have been dead. So what did the DA tell you through Officer Salinas when he testified? He told you that, you were trespassing, and had she killed you, that would have been too bad, and that would be bad on you. So in other words, he's saying that he knew, the DA's telling you, he knew that Melissa Perez, with this hammer, was going to strike and intended to strike Salinas in the head, and that would cause SBI or death, and that was her intent. And she would be justified in using deadly force to repel an invader. So the state has told you that deadly force was used by Melissa Perez, it was imminent, it was intentional. End of story. Now, what makes it worse is the state would have you believe that the totality of circumstances weighs in their favor. But that's absurd, and I'll tell you why. Because the totality of the circumstances depends upon the severity of the crime committed by Melissa Perez. She committed 4 crimes before, actually 5 crimes, before 20207. The crimes that she committed were that she... 8 minutes. I'm sorry. I'll try to wrap up.
No, I'm sorry.
All right. The crime that she committed was she struck at Salinas twice, threw a candle, struck at Villalobos. Then that was at 140-50 and 151-55. Now, what's also important is under the totality, the officer's prior attempts to control Melissa Perez, which Majeka told you in his PowerPoint presentation by analyzing all the videos that Melissa Perez said in one form or fashion 71 times, You're not going to arrest me. You need a warrant. I've been to the jail before for 45 days, 3 times. I'm not going to go. So they spent a lot of time trying to coax her out. They tried to convince her to surrender. They didn't want to use force. They told her many, many times, please, we don't want to use force. So they tried, under the totality of the circumstances analysis, to control her, but were left with no choice. So at 2:02:04, if you remember an opening statement, I believe I stood right here and I said to the folks, thank you, Christian. I said to you folks, and this is State's Exhibit 54. I didn't have a Leica scanner, but I had a little basic knowledge of screen size. And screen size here, that's like 2.5 feet from here to here. And we know from the CSI that this distance from here to here is 6 feet. So just using basic mathematics, when you estimate this is 2.5 feet, and you take a look at the distance between this wall and this corner and this railing, you know that Sergeant Flores stepped on this corner right here, and when he did step on that corner, the back of his head, and I illustrated for the jurors, the back of his head was like this, 3 to 5 feet away. Now, his life was in danger, based upon the video, 3 to 5 feet away, hammer, you know that his life was in danger. Now, what happened thereafter, I believe that both Christian and Tom handled that very well, and I'm going to cede the rest of my time to my colleague, Mario Del Prado. Thank you.
Alex, Your Honor, could I have a couple people come out to help me set this up? Thank you. Jacob or Alex, or you back there? No? Can you help me, Nico, set this up? That one. Yeah, that's fine. That's fine. Go ahead. Yeah, that's fine. Yeah, please. Thank you. May I proceed, Judge?
Yes.
May it please the court, counsel, ladies and gentlemen, I've made a lot of notes, but I'm not going to have time to talk about them all. I'm sure you'd be relieved. How did we get here? I'll tell you how I think we got here. When I told you in jury selection, I said that when Mr. LaHood was the district attorney, he started a unit called the Criminal Integrity Unit, the Crime Integrity Unit, Conviction Integrity Unit, to prevent unjust convictions. And at the time, it was in the media. It was a great unit, and the leader of that unit said, you know, I hate to think that there are innocent people in prison, but we know there are. And that was the reason that they created the unit. So to ask yourself, how did we get here? How do innocent people get to prison? Well, you got to take some steps backwards. And when Mr. Harris had up there, how did we get here? And he started on June the 23rd. We got here because the morning of June the 23rd, Mr. Harris, the leader of the Civil Rights Unit, which again, this was a big deal in the media. Joe Gonzalez, our progressive district attorney, said, I'm starting a Civil Rights Unit. Their only job is to go after police officers. Okay? So in 2023, what happens a couple of years later? Here's the big chance. It's unprecedented. There's never been in Bexar County a prosecution of a San Antonio police officer for murder on duty. So now what do we have? Well, we have these three individuals. Not just one, but three. Okay? And you would think, out of common decency, common sense, fairness, justice, that the San Antonio Police Department would take their time in looking at this. It's kind of funny, on the way down here, I see these billboards, the San Antonio Police Department, here for you. They certainly weren't there for these men, because they sold them down the river within, sounds like 4 hours. 4 hours. When no one could have looked at anything. And thank goodness that, Ben Cifuentes here, you probably noticed he doesn't care much for detail. If we hadn't had Ben, who knows this user audit trail stuff better than the San Antonio Police Department themselves, because remember, Detective Soto, which by the way should be the 3 scariest words in the English language. If you ever have a loved one and you hear that some crime has purportedly been perpetrated against them, and you hear Detective Ronald Soto is investigating, that ought to scare the hell out of you. That ought to scare the hell out of you. And what should scare the hell out of you even more is that these are 3 San Antonio police officers. What if you have a loved one that's accused of a crime, and you see the quality of the investigation, or lack thereof, the total lack of investigation in this case? If they're going to do that to their own, if they're going to throw these guys to the wolves with no concern, 871 days since this has happened, and all of y'all said, we all have a right to go home. Unfortunately, these men have never gone home. From that morning, they never got to go home. They're still living in a limbo created by these men. And it's ironic that Mr. Harris goes on and on about the government, the government, the government. This is the government right here. This is the government. And this government, you now know, was in from day one, from that morning on the decision to rush to judgment on these men, and now you know there is zero evidence. These men aren't just not guilty, they are innocent. They are innocent. And one of the things that I was thinking about the symmetry of this case, because the last time I argued a case in this court, y'all had probably had the longest jury trial I've ever been involved in, but for one, and that was a death penalty case in this court before this judge. And in that case was prosecuted, and that case was put together by a fantastic detective who, on the day that Detective Marconi was executed in front of the San Antonio Police Department, they had no idea who did it. But through the hard work, the hard, meticulous work of Detective Mark Duke, who's here in the courtroom, and who you heard testify, we were able to make that case. It was a hard case, painful case. But justice was done in that case because of the work of Detective Duke, who you now know came and told you he recently retired, and I never thought I would testify for the defense, Detective Duke told you. He never thought he would. But when he saw the injustice, the manifest injustice from day one in this case, he said, I have to get involved. I got to get involved. In my mind, the injustice of this is just so overwhelming. It is so overwhelming in this case. With the ease, in 871 days, did anyone ever stop to say, are we doing the right thing? Hold on, Are we doing the right thing here? No. And as Mr. Nesbitt said, and as many witnesses have said, this was clearly a political prosecution. Mr. Harris didn't do this on his own. The progressive DA Joe Gonzalez had to sign off on it, and he was in it for day one, right? Let's go. Because, hey, to a hammer, like the Civil Rights Unit, who only goes after police officers, these three men look like nails. So they went after him. And the San Antonio Police Department administration, that was horrible what they allowed to happen to these three men. Once again, you'd think, let's put our most experienced detective on this case. What's the hurry? These guys aren't outlaws or desperados. Which also reminds me, the other symmetry to this case, when the last time I was in here arguing about a police officer being killed in a capital murder case and Detective Duke is involved, now we're here with Detective Duke involved again, and we're trying to see that justice is done, and to hear, my mind was almost blown. All of these men here, looks like a rugby scrum over here, we're all former prosecutors. And when we heard that this prosecution unit told Officer Salinas if she had connected with this hammer and killed you, she would have been justified. She would have been justified. Think about that. Let that sink in. So if she had committed capital murder, she would have been justified. Let that sink in. Let it also sink in, as Mr. Nesbitt told you from the beginning, the language that has come from these two gentlemen. Remember, Mr. Lunan was talking about excuses. Oh, you're going to hear excuses. Their job is to see that justice is done. For a prosecutor to refer to justification, which is in the Penal Code, Chapter 9, as an excuse is outrageous. But he told you that. And remember, he also told you when they were talking about exigent circumstances. So let's consider the things that they said we're going to come forward with to show you guys exigent circumstances. There were no exigent circumstances. They didn't like any of the officers talking about that. Even though, like Officer Thompson said, well, what about United States versus Santana? He knew his his United States Supreme Court case law. Oh, we don't want to hear about that. And they didn't want you guys to know about it in voir dire either. Mr. Lunan didn't talk about hot pursuit at all as an exigent circumstance. So we know, what did they go over with you? There were no exigent circumstances. A warrant is required. She has to give them consent. Her property rights can't be violated. She can't, she can use force against them. She can use deadly force against them. You're not going to hear any of that or see any of that in this charge. And you got to think back, how did we get here? In the grand jury, when they're misinforming you of the law, and they're in front of a grand jury who just needs probable cause. And remember, I talked to you in jury selection about the grand jury is the only people that can be present are the prosecutors, and that's it, and the grand jurors. So that's like a football game where there's only one team on the field. And man, they can run up the score. You're going to score every play. There's nobody out there against you. It's not an adversarial system. And when you can misinform the jury about the law, well, yeah, you're probably going to get a indictment. I told you in jury selection, a grand jury can indict a ham sandwich. Well, for these gentlemen, these three good, decent, honorable servants are ham sandwiches. Because as Soto told you, no more additional evidence was developed from that day until he came here before you. And if you think about it, and I'm sure Mr. LaHood and Mr. Gross are going to go over it in detail, but Detective Soto, I mean, think about the messenger in this case. Think about, they're accusing these, they want to send these men, they want to convict them of first degree murder and or aggravated assault where they could go to prison for the rest of their life, and they bring you Ronald Soto, who had no experience, zero experience in officer-involved shootings. He told you that. He had zero experience in use of force training, and this whole case is about use of force. Zero experience. And if he could have gotten away with lying to you about watching all of the digital media, he would have, but for Mr. Cifuentes, and but for Mr. Cifuentes, now you know that nobody in SAPD brass watch these videos. You guys probably watch more of these videos than anybody at the San Antonio Police Department did. And that's the kind of case that they want you to convict these men beyond a reasonable doubt of. And then they have the temerity to refer to these people as the government. This is an abomination that should never have gone forward. And people should be held responsible. Not just these men, but their superior. And not just Ronald Soto, but his superiors. It is truly an abomination. And the fact that this is televised, because at the end of the case, Mr. Lunan, I'm sure, is going to come forward and tell you, send a message. Prosecutors always, we all did that when we were prosecutors. Send a message to the community. Well, I'm asking you to send a message to the community. Send a message to Joe Gonzalez. Send a message to Chief William McManus. Send a message to all of law enforcement all across this state that the theory that these gentlemen are putting forward, all you had to do was, as Soto said, the pattern. You know, if you try to arrest her and she resists, don't. That's it. She doesn't get hurt. You don't get hurt. So if you try to arrest somebody and they resist, just step away. Because if you try to do your job, you could end up like them. Let's say some guy, you know, he grabs his wife, severely beats her up in the front yard of his house, and then drags her inside the house. The neighbors call the police. The police show up. And the wife is like, they're like, "Are you okay?" They're yelling. She's like, "Yeah, I'm okay. Go home. Just go home." And the husband's like, "This is my property. You guys are trespassers. You guys are burglars." Remember, they told Officer Salinas that he was a burglar. That y'all are burglars. So, once you've gone through the ringer with these guys, any sane officer is going to say, "Oh, well, you know what? We better go home." And they leave. And then that night they hear, "That woman's dead." What do we expect from our officers? And one of my favorite justices, because I went to Holmes High School, Justice Oliver Wendell Holmes, in a self-defense case, famously wrote, "Detached reflection cannot be demanded in the presence of a knife or a raised hammer." Because life isn't simple. Reality happens quickly. Split-second decisions have to be made. And I'm sure all of you have probably had to make a significant split-second decision, but not of the nature and quality that these men did. Okay? We ask these men to run to danger, to run to trouble, when all of us are walking away from it. But they're damned if they do, they're damned if they don't. And the other symmetry in this case, besides me and Detective Duke, is you think about the first three officers in this case, and these three men, those first three, they're still working for the San Antonio Police Department. Rojas, who at least, you'd think he would at least have the moral decency to come to you and to say, because as I told you in opening statement, he could have ended this. If he would have done what he was supposed to, we would never be here. we would never be here. But he didn't. And he had excuses for that. But you would think a morally decent man would have come to you and said, you know what, yeah, I didn't have to arrest her or emergency detain her, but man, I wish I had. I wish I had, because this wouldn't have happened. But no, he didn't. Ramos, well, I already talked to you about Ramos in opening statement, about what kind of quality guy that is. He's still a San Antonio police officer. Salinas, he knew about her mental health history also, just like the first two did. But he never said that to Sergeant Flores or anyone else. And it's unbelievable when these guys come in and they say, well, Sergeant Flores didn't go ask them, didn't go question them. Do these men not have any responsibility? If you'll notice, and I told you in opening statement, they're all standing back and not doing anything. They're not doing anything. Remember, Rojas was so lazy that when he gets in there and that man, Mr. De La Rosa, it must take him 5 minutes to try to put his shirt on. Rojas just stands there and watches him. The man can barely make it to the bathroom. Rojas just stands there and watches him. But he's still in the San Antonio Police Department. These men, and you saw by their body cameras what kind of men these are. Protect and serve. You saw them out in the community helping those two different individual men. Trying to help them out. No, we're not going to arrest you. I'll give you a ride. And it's funny how sometimes fate works. What if Alejandro the guy's mother didn't live on the northeast side, and he says, get in, I'll give you a ride, and he's taking her home. He wouldn't have been out there that night. These three men were responding to an officer in trouble. You know, the media still reports that they were responding to a mental health call. Even today they were responding to a mental health call. That's why y'all are in such a great position, because you've heard the truth. You've heard the evidence. Can you just imagine if there was a jury and all they had was Ronald Soto, who lied on the affidavit to another judge about what was there, who had absolutely no experience in officer-involved shootings, who had absolutely no experience in use of force training, who lied about watching everybody's body camera, who lied to you about making this decision on his own, because you know that's just factually impossible. He sat there and lied to you. Let's call it what it is. He sat there and lied to you. And we brought you 4 experts. You know how many experts they brought you? 0. They want you to send these men to prison for life, and they brought you 0 experts. A big fat 0. Soto certainly isn't an expert. He doesn't know anything besides not being able to tell the truth or do a competent investigation. You get back to how important measurements are, and that Dr. Martinelli and that presentation by Angelos, that was eye-opening. So you can see Melissa Perez was actually like 3 times closer than it appeared on the body camera. That was extremely eye-opening. The measurements were extremely eye-opening and important, but Soto couldn't even be bothered to do that. Half of the apartment wasn't searched. And initially they talked to you about, oh, well, there was no evidence that she'd stolen anything because Soto didn't look, and we didn't even have to call him because it was admitted. Soto admitted it. The maintenance man, Kenji Uno, found all the stolen batteries she'd been stealing, as she said on the video, from the fire alarm systems. They were all in there. As a matter of fact, one of them sitting on the little table outside her front door. But once again, consistent with his bang-up job, Soto didn't notice him. And the great CSIs, they would have if they would have been told. But no, Soto's like, no, they're good. I'm not going to tell them anything. It's outrageous that there was no Leica system used that day, the next day, for a full year. They had to go back out because, once again, that investigation wasn't complete. So a year later, they go back out. CSI Diaz told you, yeah, that's really unusual. I've never had to do that before, where I go back to the same place a year later. That's the quality of the investigation. If you'll recall, in jury selection, I told you that the roots of beyond a reasonable doubt are so important, right? And I talked about, held up the book, the theological roots of proof beyond a reasonable doubt, okay? Because jurors, they were drilling it into jurors that this decision is so important when you're considering the lives of not just one man, or two men, or three men, that your own immortal soul is at stake if you make a mistake, right? Because you don't know these men, so they wanted to get across to you how important this decision is. It's extremely important. And I think, frankly, it's disgusting that y'all are asked to put yourselves in a position to convict these men beyond a reasonable doubt based on zero evidence. Because 20 years from today, you shouldn't be able to look yourself in the mirror and say, oh man, did I convict not just one innocent man, but two or three? And that's why this burden of proof chart, take a look at it. I think they're going to have it again. What this really means, because if you remember going back to jury selection, you can clearly be convinced. Because remember, below proof beyond a reasonable doubt is clear and convincing evidence. How much time do I have?
We got 58 minutes total.
Okay. I just have a few slides I want to show you. You can be clearly convinced that these men weren't justified. I mean, I think they're innocent, right? But even if you want to get to the point where you say, you know what, I'm clearly convinced that there was no justification, then by your oath and what you told Judge Ronhell, you're all required to return a verdict of not guilty. That's how strong justification is. And that law wasn't written just for these three men. As you all told everybody from day one, we all have a right to go home, right? Self-defense is inherent in being a human being. As everyone has said, this is a tragedy. There is no doubt about that. As Mr. Goss told you early on, what can look awful can be lawful. There is no, anytime, and I think one of our experts said, anytime you have an officer-involved shooting, it's not a pretty picture, necessarily, right? It's not. But sometimes the choices are between, as I said in jury selection, between the horrible and the terrible. Because sometimes, and hopefully none of you are ever put in that situation, but sometimes choices have to be made, and decisions have to be made. And in a split second, do you make the decision, I'm going to protect my brother officer, and it's not just brother officer. As I told you, under 6.6 of the Code of Criminal Procedure, they have a duty to prevent injury to everybody, including Ms. Perez. And if there would have been any civilians there, they would have had a duty to protect them as well. As I said, they didn't get up that morning hoping, as you saw from their behavior before with other people, they're good and decent men. When they swore an oath to defend the Constitution, not just in the military, because Alejandro and obviously Villalobos are veterans. When they defended this country with their life and defended the Constitution, they have a right to count on their government, particularly the Civil Rights Unit, making sure that their rights are not violated, and not to just give them lip service of a couple of hours. They have that right. And then when they further, all three of them took the oath as police officers to protect and defend the Constitution and laws of the United States, they have a right to count on those laws as much as anyone else. And this is a tragedy. This is a systemic tragedy. And besides people in SAPD brass, people at the top of the Bexar County District Attorney's Office, a message needs to be sent. Unfortunately, you look at our society and our policy. Mental illness is rife, and it affects almost everyone's family. I thought that was interesting when Mr. Lunan, went after Lieutenant Majeka. And, Butch Majeka said, no, I've arrested police officers. He said, you probably don't hang out with people like Melissa Perez, right? And Butch said, no, I've got mental illness in my family, a lot of people. I've prosecuted police officers. I've arrested police officers. I've arrested my own cousin. I've kicked my own brother out of the house for smoking marijuana. You look at those four experts, and frankly, I have never seen a team of experts put together like those people. And frankly, they were not touched by either one of these prosecutors when they were cross-examined. They were not touched. Their testimony and their grasp of the science and the evidence was unmatched, including Dr. Martinelli. And they all told you what a horrible investigation this was, and they all told you about the politics of SAPD, and they told you about Sergeant Pedraza, who said at 8:30 that morning, Chief McManus was already telling people this was a bad shoot. This was a bad shoot. And his captain, Pedraza's captain, telling him, because Pedraza, who works at the training academy, and I'll talk about that, was told to keep his mouth shut. Keep your mouth shut, because it's more important politically, because what McManus was worried about, remember, he'd established a mental health unit, and he was very proud of it. And it looks bad how this woman died. As the media said, she was just standing in her own apartment holding a hammer. That's all she was doing when these three men opened up on her for absolutely no reason. You know that's not the truth. You know that's not the evidence. But a lot of people believe that. And, another thing I forgot about Detective Soto. The reason that there were so many lies, half-lies, omissions, is because he didn't even know what exculpatory evidence is. Every single law enforcement officer and anybody in the justice system knows exculpatory evidence is evidence that shows you didn't commit the crime. And as Detective Duke was telling you, I want to make sure when I do my investigation that there is no exculpatory evidence to show maybe this person didn't do it. I need to look at all of the evidence. And remember when Mr. Goss told you in jury selection, who's responsible for bringing you guys all of the evidence? It's at this table. And at the end of this case, if you have any questions that weren't answered, whose responsibility is that for those questions to be answered? It's at this table. But in the month of this trial, all of that has come from these tables. Because Mr. Cifuentes' mastery of SAPD procedure and user audit trails, and because of, frankly, the unbelievable cross-examination done by these other gentlemen. Thank God these officers had that defense, because if they didn't and all you were brought was Detective Soto and the, frankly, crazy theory by the prosecutors, that's how innocent people get sent to prison. That's how innocent people get sent to prison. Now, when I say it was a tragedy, what happened to Melissa Perez and the systemic problems, I want to address it this way. There's a lot, and these men did not know, obviously, that she was mentally ill, right? However, even if they did, somebody comes at you or one of your loved ones with this, and I'm not going to raise the hammer tomahawk style to you, but when I get this close to you, and maybe you're sitting in your living room behind and there's a big open window there, and there's a big old glass door there, and I'm running at you with this, I would bet you that all of you would feel like that's either the use or attempted use of deadly force. Okay? and anybody is entitled, not only under the law, but that's human nature. The urge to live cannot be stamped out. These men did not want to take it unlawfully. They were put into a horrible position. These are reasonable men who were thrust into an unreasonable moment. And the charge is not going to have anything in there about, well, alternative plans could have been made, or they could have walked off the patio and come back the next day. There's nothing in here for that. There is absolutely nothing in there for these men to move you with any kind of now new theory about what should have been done. Because in a split second's time, as we said from the very beginning, nobody's perfect. I think the only perfect person in this world lived 2,000 years ago. The law doesn't ask perfection for good reason, because no one's perfect. The law asks reasonableness. And they had a plan. The plan was reasonable. But as Lieutenant Majeka and Mike Tyson say, hey, everybody's got a plan until they get hit in the mouth. Obviously, not every plan goes according to the way it was intended to, but these men would not have used deadly force unless they were forced to. And unfortunately, I think y'all may have to consider the fact that Melissa Perez may have wanted those officers to take her own life, because you don't tell officers, shoot me, and go after them 4 times with a hammer. And after you've been fired on multiple times, take a couple of seconds and make another run. Right at 2 other officers. Why might she have done that? Well, and this is hard talking with the family in here, but we said at jury selection, we're going to have to ask tough questions. And y'all all said we could. Because if your loved one was sitting where these men are, I think you would want attorneys who are going to ask the tough questions. Right? And y'all said that we could.
3 minutes.
The family did what they could for Melissa Perez. But like a lot of us, whether it's mental illness or drug addiction or whatever, there comes a time when there's not much more you can do, and you get tired, you get frustrated, life moves on, you've got children and things to take care of. But you heard from the family they hadn't had any contact with her, Daisy Nieto, for months, her own daughter for well over a month. Maybe Melissa Perez was like, I don't know. We don't know. I don't know. It is very significant, though, and the last couple of things I want to leave you with is that on that 4th emergency detention call, because the family themselves, when they couldn't handle Melissa Perez, who they told you was violent and aggressive and unpredictable and didn't like being questioned, when they couldn't handle her, people who knew her and loved her, what did they do? They turned to the San Antonio Police Department. What do we all do when we can't handle something and it becomes overwhelming? When it becomes dangerous or chaotic? We call the police department.
2 minutes.
And now we're expecting them to make perfect decisions. Not reasonable ones, but perfect. That 4th call, about a month before June 23rd, Daisy Nieto calls the San Antonio Police Department. Once again, Melissa's experiencing audible and visual hallucinations. Daisy's worried about her mother. And Melissa knows the police are coming, she leaves. Because it wasn't about protecting her property. It was very clear, as Sergeant Miller told you, she just did not want to be arrested. And she could not say that enough. She was not going back. She was not going back, and no one was going to arrest her. But when San Antonio Police Department gets there, she's not there. Okay? Now, 2 things. This was a month before she died. The family could have said, hey, we know where her address is. Can you go do a welfare check on her to make sure she's okay? No. The police officer who responded, did he say, hey, I can go, or I can call somebody if that's in a different district to go make a welfare check on her? No. But let's dump on these 3 men. The last thing I want to tell you is this. One of my mentors had a great story about, he called it the wise old man and the smart aleck or smart ass little kid. And the smart aleck kid says, I'm going to show this wise old man up. I'm going to show him he's not so smart. So he gets a bird, the kid does, and he's got it in his hands. And he goes up to the wise old man and he says, wise old man, the bird in my hands, is it alive or is it dead? Because the kid's thinking, if he tells me it's alive, I'll crush the life out of it. If he tells me it's dead, I'll open my hands and the bird flies away. So he goes up to the wise old man. Wise old man, is the bird in my hands alive or is it dead? And the wise old man says, my son, the bird is in your hands. We've been shepherding these three fine, good, decent, excellent officers since that day. And now we pass them into your hands. And I ask you to seriously consider the origins of what beyond a reasonable doubt means. And I know you will, because this has been a long time and all of you have paid exquisite attention to this. And as it's been said before, if any of us have said anything that's angered you or thought was ridiculous, please don't hold it against these three men. Hold it against us. Okay? But thank you for your time. Thank you for your attention. And please do the right thing and send these men home, finally. Tell the DA's office, tell the San Antonio Police Department, society has a lot of problems, but don't put it off on these men to be the answer to all of them. Thank you very much. I didn't even get to show these slides.
Just, we have a break to set up, please.
All right, let's take a short break.
All right.
may be seated.
All right, welcome back, members of the jury.
Judge, may I proceed?
Yes.
Thank you. They had a duty to go in. And I told you in opening statement, they had a duty to go in and they had a right to go home, right? They have both. I want to talk about the duty because from even the state's witnesses that you heard, Officer Chernak, even Detective Soto at times, talked about the duty to go in. And what is that duty? The duty is that when we don't have to go in, when we don't have to deal with whatever's happening in this community, when we don't have to do it, we ask them to. 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 This whole courtroom is full of people who have a duty to go in when we don't have to. And that means something. It's important. It's important for us to live as we want to live in a community that's safe, to live in a community that we can raise our families. I mean, I raise my kids here. I worry about, just like all of us worry about, what's going on out there and what can happen to them, right? Like, it's important. It's important that we tell them that when you have a duty to go in, we also give you the right to go home, because these are men and women that put on that uniform, and they all have spouses, right? And so when we talk about the right to go home, their husbands and their wives will not let them do their duty to go in if we don't guarantee them the right to go home. It won't happen. You can ask any one of them. They don't let them out there. They would never let them out there. If that were my wife, I would not let her. If I was out there in uniform like that, my wife would never let me not come home to our kids. Never let my two kids not have a father. So we have to balance that, right? That's what this whole trial's been about. How do you balance the duty to go in with the right to go home? How did the state do it? The government. And they are the government. They are the government. How did the government do it? They said, well, they didn't have a duty to go in. They told you that. He had to tell you they were wrong. Right? I mean, that's the first thing that they did. The first thing they came up and told you. They didn't have a duty to go in. And now what are they saying? Now that they've been told and you've been told that they were wrong, as Tom said, you fooled me once, shame on you. You fooled me twice, shame on me. Right? So now what are they saying? I guess they're saying they didn't have a right to go home. But they did. And as you can see through the trial, they did everything that they could. They did everything that they could. Good men, good officers. You know, I was thinking about it. What are the chances that we would happen to have on Officer Alejandro and Officer Villalobos' video exactly what they look like when they weren't at this scene? Exactly what they look like in the call right before. What were they doing? They were helping people. Because that's another thing that we asked them to do, community policing. Another thing we asked them to do is don't over-police. Don't go to every guy who's drunk and had a problem with the missus and start kicking him out of his seat. Don't go to every person. Don't go to every person who's coming shirtless going, I don't know, I've been in this fight and everything else and I can't get over to where my mother lives. Don't go and say, I don't care what happens to you. Get off the street or you're going to jail, right? They didn't do that. And that's what you see immediately before for both of them. They get called out from that to this. And why did they get called out? Because Jonathan Salinas is getting threatened by Melissa Perez. Because Jonathan Salinas was attacked by Melissa Perez. Because Jonathan Salinas was hit by Melissa Perez. Because Jonathan Salinas was almost killed by Melissa Perez. That's what the evidence shows. It's what it proves. So I want to talk about this. I consider trial by jury as the only anchor ever yet imagined by man by which government can be held to the principles of its Constitution. Mr. Harris was right. We did talk about that at the beginning. We talked about that at the beginning of the trial, but we didn't talk about it the way that he is, and honestly, Jefferson's not talking about it, about these men as the government. These men are the government. They're the representatives of the government right now. And what Jefferson is saying is these men have to be held by you, have to be anchored by you to the principles of our Constitution. What does it look like? The principles of our Constitution. The right to trial by jury, the right to never be convicted unless the government can prove beyond a reasonable doubt that you were guilty without justification. These are the principles. This is the anchor. It's you. That's what he's saying. This is you. This is the ship anchored to the principles. This is our government, them, and all of us that are on the ship with them. So what does it look like? This is how the world is supposed to be. The government and all of us are supposed to be anchored to the principles of our Constitution. That's what it's supposed to look like. Well, what's the first thing that they did? The first thing that they did was they said in their closing argument, let me show you 3 other officers who did some bad stuff. That ship starts sailing out into the harbor. It's losing its anchor. Because when they do that, when the government takes 3 officers who they had nothing to do with, and they spend 20 minutes in a closing argument after we've had a 4-week trial, they spend 20 minutes talking to you and showing you these 3 officers that they had nothing to do with. That ship is going. That ship's moving out. What else? Detective Soto. When they bring Detective Soto and he makes assumptions, and the ship keeps going out. And it's going to keep going out, and it's going to keep going out into open water. And God help us all if our ship gets out into open water, where there's no anchor for our government to the principles of its Constitution. That's what this is about. It's not about what Mr. Harris said. One thing he did say is hold the government accountable. I guess meaning these guys. These guys. Them. And look, as Tom said, I sat at that table for 10 years, proud to sit at the table. I was. Did some good things. He was the elected DA. He hired me over there. I was proud to work for him. We did good things. We did never do anything like this. Never did anything like this against men like this, who were in that position, who had every right to go home to their families. Eleazar Alejandro just found out on Saturday the baby that his wife's carrying is a boy. That's what's happening right now to him, right now in this trial. That baby's father is on trial for murder. Murder. For what we have seen. Where did that start? It started with Chief McManus. Didn't like that there was a mentally ill woman that got shot. We don't like it either. Nobody does. What Tom said to the family, I agree. You know, and really going along with everything, if there's anything that we've done that's been offensive, you know, and I'll give you an example. The state had an expert back here, Chuck Joyner, right? And I was doing something in cross-examination, and I had been upset with their expert's opinion and their expert's ideas and their expert's conclusions about these men. I have not liked it. And there was one point when I looked back at him, and he was sitting right there, and I looked at him. But then Melissa's family thought I was looking at them. And I wasn't. And I apologize, because I wasn't. I was looking at him, because I'm passionate about that. I'm passionate. But if anything like that, if there was anything that would happen, that you thought, oh, I don't like what he did, or what he did, or what he did, or what he did. You can't hold it against them, because see, that's what they're trying to do. I don't like what Ramos did. I don't like what Rojas did. I don't like what Salinas did. Salinas never should have gone in the window in the first place. Who cares? At this point, they didn't know that. They don't know anything that's going on. But you hold it against them, and this keeps going out that way. What are you doing when you do that? What are you doing when you play 20 minutes of that? What's happening when that happens? We know what's happening. They're trying to hold the actions of others against them. We all know that's not fair. We would all argue against it if it happened to us. When we were kids and we had our siblings and our parents blamed us for something that the sibling did, it's not fair. But now we're all grown. And they're grown. And they're grown. And what they're doing is wrong. Because now it's not just about who gets a spanking, who goes to timeout. Now it's about who goes to prison, who's a convicted felon, right? Remember, there's no probation for murder. You convict those men of murder, you're sending them to prison. That's what they want you to do. That's what they're asking you to do. But it could be State of Texas versus Maria Salinas, Travis Thompson, and Sergeant Rivera. I told you in opening. If the people in the front were in the back, and the people who were in the back were in the front, these chairs would have been filled by 3 other good officers. Maria Salinas, good officer. Travis Thompson, good officer. Sergeant Rivera with the beanbag shotgun, if he's in front and he shoots the beanbag shotgun and kills her instead of Sergeant Flores being there, We're all sitting, 3 different people sitting here. But the facts would not have changed. The facts would not have changed. One of the things Detective Duke said from the beginning is, how do 3 people make the wrong decision at the exact wrong time? I mean, at the exact same time. How do they do that? And then 4 other people behind them are doing that. How does that happen? It's because it wasn't. It's because everybody there reasonably perceived this as immediately necessary in order to save themselves or another. That's it. You don't need anything else. Why do you think that they say, hey, they've never tried 3 officers at the same time? It's because when 3 officers are doing something, it's reasonable and immediately necessary. There's no cowboys here. There's no people that were cocked off and popped off and trying to just hurt somebody. These are all people that were doing what they could to try to get her into custody safely when Rojas didn't do it, right? And to protect each other. So this whole thing, how we got here, that is how we got here. How we got there and how we got here is that they wanted to make you believe that 3 other officers who had nothing to do with these 3 officers, that their actions can be attributable to them. The prosecutor's opening statement was all about how 2 hours had passed. And then you figure out, well, no, actually for them, 15 minutes had passed. That was it. 15 minutes. They're getting on the scene trying to figure it out. For 2 hours, she has not been cooperative. For 2 hours, they couldn't get her. And everybody told you that they had to. There was no situation where those officers were going to leave. And they could argue, well, nobody was threatening the old man. It's debatable. When she's in that kind of situation, you never know what's going to happen. But regardless of that, you can't assault officers and just everybody go home. You can't do it. It's not how I said in opening, it's not how it works. It would be crazy if that's how it works. This room would be empty and nobody would be in a uniform if that's how it works. And then where would we be? That's ultimately what Mario said, and I know what Nico's going to talk to you about. Officer Chernak, he said we had a duty to go in. He said, Jonathan Salinas, I would have done the same thing. Our plan was to get her into custody safely. Our plan. Chernak's plan, Sergeant Flores' plan, Officer Villalobos' plan, everybody who's trying to come up with something. You know, no good deed goes unpunished. They're all trying to figure out something. And the people who tried to figure out something, as long as they were on the front lines trying to get this done, putting themselves at risk. You know, I mean, I can't imagine, you know, Officer Villalobos' wife, I mean, Mitzi's sitting right there, I can't imagine when she sees her husband sticking his head into a window to unlock a door and almost getting killed for it, almost leaving that child without a father, their little boy without a dad. I can't imagine how that feels, because I would think it says, hey, don't stick your head in any more window. Don't do it anymore. Why? What did it get him? It got him into this chair. It got her into that chair. She sat here the whole time too for her husband. And what did it get? Right? So that's what happens if we do this. If we send that message that they want you to send, I guess, to the police, what the message you're going to send is, don't ever go in. Don't ever help anyone. Don't ever make an arrest. Leave. Officer Tran told you to do what was necessary. Look, I mean, looking at his plan going in with a taser like that, I think we've shown it would have been probably disastrous for him. Honestly, if she met him in the back hallway and he didn't do what Officer Villalobos was able to do, which is try to get a taser and a gun at the same time to do that, if he couldn't do that and he just had a taser, that could have been disastrous for him, his plan. But he was still trying to make a plan, and he wanted it to be non-lethal, and so did Sergeant Flores, and so did Officer Villalobos. That's why they went in when she dropped the hammer. Mark Duke. So there's the art of investigating and the science, right? We showed you 2 different things, the art and the science. So Mark Duke talked about the art of investigating. The ability to communicate is the best tool a homicide detective has, and you heard that Detective Soder didn't interview anybody. Neither did anybody in command staff. They took some statements, didn't interview, and what they did was they deprived themselves to get to the truth. To find the truth, they deprived themselves of their ability to find the truth by not using the best tool a homicide detective has in order to get to the truth. He also told you he would have done the same as all 3 officers if he were in any of their positions. That's important. That's important because when you have other people who have been trained in this, who have investigated this, who have looked at this, and who have spent, I think he said 200 hours or more looking at it, and he's saying, look, I would have done the same. And Mark Duke is not any kind of man that if he didn't feel like that he would come up here and testify to it. He's an honest cop, always was. That's why we called him, because as prosecutors we used him, and just like Mario said, he's a good detective. He's good. He's solid. And that's why we wanted you to see him, what that looks like in contrast to what they brought you. Salinas, Nico asked him, did you know that the state's theory of the case is that if Melissa Perez had been successful in her efforts and would have killed you, she would have been right to do so. Yes, they told me that in pretrial. They told them that in pretrial. How does that make you feel? Upset because they're saying her property was worth more than my life. And here's what we found out. They're telling officers this in pretrial. The district attorney's office in Bexar County, where we all live, are telling officers in pretrial that if Melissa Perez would have killed you, she would have been right to do it. And then the judge said, wrong. The judge said it's completely wrong, it's completely false. You might have seen us over here. Everybody is going, because we all know, we all practice in all the other courts that they're not trying to convict 3 police officers. We all practice over there. And in each one of those other courts, they wouldn't dare say that. They would never say that to their police. But here, they just turned it around to get a conviction because Chief McManus and Darrell Harris are sitting at 8:30 in the morning or 9:30 in the morning or 10:30 in the morning. These officers, it's not justified. I'm not saying you treat these guys any better than you would treat anybody else, but you definitely don't treat them worse, and they got treated worse. There ain't nobody is going to take that kind of evidence on that kind of case when they are involved in this kind of situation and file those charges when they did, unless there's what they call that high jingo, that political nonsense that put 3 men in a chair for murder, 3 men mugshots for murder. 3 good men, mugshots for murder. And it doesn't matter what you do today, those mugshots never go away. Never. They'll be up there forever. But you can at least rectify that harm. Well, what does it mean with Officer Salinas when he says that? What does it say about their prosecution? From the very beginning, you'll notice they always said, warrant, need a warrant. She was justified to protect her property. Warrant, need a warrant. She was justified to protect her property. Warrant, need a warrant. Justified to protect her property until the judge told them to stop it and cut it out. But until the judge told them to do that, that's what they were talking about. What did they not talk about? They never said at the beginning that Melissa Perez was not presenting a threat of immediate and necessary deadly force that they would have to defend against. They never said that. It's because they knew that she was. They knew that once you all saw the videos, that you would see that she was. They knew it. So they didn't argue that. They made these, well, frankly they are. They're crazy. It made us react to them because it's wrong. To the point where the court has to tell you it's wrong. That's how you know it's wrong. It's not me telling you. The court had to tell you that they are wrong. When we look at this, when we look at what she did in response to Officer Salinas, we see the hammer outside the window. We see the candle. Now look, I put a picture of the hammer outside the window to show when she's throwing the candle, to point out what Butch Majeka was saying, which is if you put a hammer in that hand can extend with the hammer all the way to the trim. And that means that she was, later on, when Officer Villalobos shot through that wall, she was still a threat of deadly force. In his mind, we know that she was down at that time. But we don't judge. See, Detective Soto would say, well, the door was locked. But if they believed it's unlocked, you can't judge him for that. Detective Soto would say, well, she was already down, so what is he shooting for? She's already down. He didn't know she was down. There's no way. Not one shot was fired by any of these 3 officers after being told that she was down. Dr. Martinelli. So Detective Duke and the others talked about the art of investigating cases. Butch is kind of both. Ron talked about the science. Dr. Ron Martinelli talked about the science of evaluating use of force cases. And he told you that all 3 officers were justified in defending either themselves or their fellow officers using deadly force. Now, you know, one of the things that he talked about with Officer Villalobos, he answered it in response to Cross, was at the time that Officer Villalobos was using force, he was using deadly force to protect Sergeant Flores, which that's what the law says. He is totally entitled to do it. But he also said, and it didn't get highlighted because of course they didn't ask him again, but he also said, but she was still a threat to all 3 officers until they knew she was down. And we talked about that in terms of like how she was, like when you're looking at like Officer Flores' body-worn cam, it's hard to see there, but that's the taser out. And I just wanted to remind you that when Dr. Martinelli is talking about the ODA loop for Officer Villalobos, his was more because he's going in non-lethal. He's going in with a taser. So he has to take more time once this is all started to try to get his firearm out because he doesn't know what's happening. He doesn't know where she's coming from. He doesn't know what she's going to do. So he's taking more time than the others. And so because of that, and he doesn't see on either side that she's going to be there, he has to assume that either doubt, but there's no way to know that, or that she's up against the wall about to launch an attack. And if she's up against the wall about to launch an attack, we talked about she can launch it around the window, she can reach around that window and hit any officer that's there. She can launch it at Alejandro because he is just presenting a pretty good target. And they try to argue she didn't hit what she was aiming. She hit what she was aiming with that candle. She was aiming for Salinas. She hit Salinas. It's because these distances that look so far on the body cam are actually very close, and it wasn't hard for her to do. She's looking from here to here, from here to here, from here to here, from here to here, from here to here. This is how close she is to Officer Alejandro. She's this close. So if I could take a hammer right now and throw it here, 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 that's how close she was. If she wanted to go out that window. We obviously know about the door, the dangers that that door presented, and we talked about it. Here's Officer Villalobos unlocking the door. So we know that he knows, and this is important, he knows what's in there. It is not unreasonable if you know what's in there to fire through a wall, as the experts all said, if you know where she is and she still potentially presents a threat. And so he did, and it just so happened, and that's why they didn't charge him. They charged him at first with murder. They charged him at first with murder when they had no right to do so, because he didn't actually shoot her. And now, though, they haven't. They haven't charged him with murder. But he's sitting here in the same place. We could have tried him separately. We could have. But he's sitting here in the same place because he's not going to say that they were wrong and he was not wrong, right? That's not the way that this goes. Because I didn't shoot her, so therefore I wasn't wrong. No, he's going to say, I used the force that I used because I had a duty to go in and a right to go home to my family. And I know they have that same duty and that same right. And so if Officer Villalobos had shot her, it would have been justified. Officer Alejandro, if he had shot her, justified. Sergeant Flores, we talked about, we know that that's the one bullet, completely 100% justified. Completely 100% justified. Because beyond a reasonable doubt, if the burden's too high, they were never going to be able to get there on these facts. The way they get there is if, she's no threat. But look, every time that she was no threat, every time she had gone back, every time she didn't have any weapons, anything else, nobody shot her. They're doing what their training says. We're not going to shoot a woman. We're not going to shoot a woman. I don't care if she's drunk. I don't care if she's angry. I don't care if she's abusive. I don't even care if she's attacked an officer. We're not going to get revenge, because this isn't about revenge. This is about doing the right thing at the right time. We're going to try to get her into custody safely. And they tried. But they didn't. It just points out that she's using that wall there, and then you see the numbers that Tom and Butch talked about. I mean, this is where the shots were fired, right there. So Officer Villalobos, even in that situation, was reasonable in that if she were still standing up ready to launch an attack, and the next one is going to come and they don't know where it's coming from, if she were still standing there, he would have shot her in the place that he is trained to shoot her. But she wasn't. She was already down. So I want to talk about this. We talked a lot, and y'all have already seen this. 3.7 feet. 3.7 feet to the door. And we talked about why that's important. But if you look here, right, that's why we're talking about it. Right here, 3.7 feet, we saw that she was moving at almost 7 feet per second. Dr. Martinelli told you that half a second from that point, and that is Sergeant Flores' first shot. Half a second from that point, she's there for all they know. Because for them, the door is unlocked. And we talked about what that means. If she is there, Sergeant Flores can't shoot her because he might shoot Villalobos. Villalobos can't shoot her because he might shoot Sergeant Flores. Alejandro, look where he is. He can't turn his weapon over there in their direction and start firing. So at that moment, this is the last possible second. Just like Tom said, it's the last possible second. The last possible second. Until they're in a crossfire and they all have to drop their weapons. And if they all have to drop their weapons, they're in a melee with a woman with a hammer. So she has the weapon. They would all have to disarm themselves. And they would. Because they're all trained, and that's why I kept saying, they're all trained about crossfire. They all know that, once there's an officer there, I can't shoot. And once they can't shoot, then they have to reholster. I mean, they don't want to drop it because then she can pick it up, but they have to do something to not shoot, or they're just holding it in their hands and down while trying to one-handedly fight a woman with a hammer. It's the last possible second before, as far as they know, this occurs. And if that occurs, then somebody's getting hurt. And it's not just Melissa Perez. One of those officers are going to get hurt because of what happened. And if they didn't pay attention to their training, which they all did and showed you they did from the beginning, but if they didn't, and they weren't a crossfire, if Alejandro panicked and shot over there, or Flores and Villalobos start shooting at each other, basically trying to get her, trying to protect each other from her, and end up shooting each other. Those are the kind of tragedies that they're trained to avoid. So Sergeant Flores waited till that moment. Now you saw that Officer Alejandro shot earlier. It's because, and his shots were completely justified, it's because when he sees her running across that room with that hammer, he knows that this is the eventuality, that this is the place, that this is what can end up. They all believe that door's unlocked. So when he shoots her, he shot her when she started raising the hammer, knowing that he had already shot at her, knowing that she had already attacked Sergeant Flores, knowing the window and all of those things. But now you have Sergeant Flores, who is shooting before that eventuality. That would be a disaster. Now, Detective Soto said, well, the door was locked. They didn't know it. And just like everything that they've done in this case, everything, they take these facts that they couldn't possibly know. She has mental illness. She said that. She said this. She said that. Look what, I mean, I can't believe that they played Ramos doing that to her again, stirring her up like that. Because trying to do that is trying to get your emotions to hold them accountable for that. It's not fair. It's not fair. This thing is floating out. The anchor is untethered. It's going. And it's going to continue to go and it's going to fall right off that edge. That's what's going to happen to us if we allow them to do that. Like Mr. Looney, he's going to get up. Remember, whatever he argues, whatever he says, whatever he argues and whatever he says, he is the man that told you from the beginning that they needed a warrant. And the judge had to tell you that is not true. He's the man that told you from the beginning that she had a right to protect her property. See, as lawyers, we do have a duty, a sacred duty to the law to explain it properly, to not try to confuse you. Because I know that weighed on some of your minds. I know it weighed on some of your minds that, gosh, did they need a warrant? I mean, if they needed a warrant, is that right? Gosh, can she protect her property? And were they there lawfully? And the judge had to tell you, no, that's not. Remember now, when he argues again, first time, shame on me. Second time, first time, shame on you. Second time, shame on me. Third time, shame on who? Shame on them, I think all the times. Shame on them, because that's not what it's about. And shame on them for saying how we got here and then just playing you a bunch of videos of the Three Stooges at the beginning. Honestly, I mean, the three people who should not, I mean, Salinas being the least, but you got Rojas and Ramos. Rojas does his job. They don't have to go out there. That never happens. Ramos doesn't do what he did, and she's not maybe in that kind of situation where she's willing to start killing officers with a hand. And then Salinas, who is going in, and remember, you heard that Salinas called Night CID, talked to Night CID, and he testified to this. He talked to Night CID, he called Sergeant Flores, he said, I called Night CID, we're going to go in, and Sergeant Flores said, okay, keep me updated. From the beginning, they're the ones that told you, no, Sergeant Flores is the one that told him to go in there, that told him he has to go in. Sergeant Flores demanded he go in that screen, demanded he go. Didn't happen. So the people that tell you those things should not be able to argue to you now to try to get this conviction that should never even be here in the first place. To try to do this, it should never have done. And I can tell that there was a lot of times that you guys are tired of this. You've heard it from every angle. You've heard every possible way. You've seen everything from every angle. The thing about it is we can't read your minds. I don't know what's got you. I don't know where you are. I don't know where any of you are. I can't see it. I can't see it, and they only have one chance. They only have one shot at this. So we presented everything. If it was expert overload because we had them all and they didn't have any, I'm sorry. But who was I going to leave out? Who was Nico going to leave out? Who was Ben and Mario? Who was Tom and Christian going to leave out? Because we can't afford to leave anybody out. But you can tell them how you were thinking, and if you think that this was too much, if you think that you were done a long time ago, you tell them that with your verdict. Because we had to bring you most of it. But I'll tell you what, because we all know cameras are here, everything, and cameras don't matter, but you go back there. You go back there and you come back in here quick, that tells everybody something. Tells everybody you should have done this in the first place. It does send that message. And I'm encouraging it. Because the only thing you're going to hear left from Mr. Lunan, you're going to hear from a person that didn't tell you the truth about the law, that wasn't right about it. The judge told you it was wrong. That's all you're going to hear left. I mean, Nico, you're going to hear from him, and he's going to go through a lot of this other stuff as well. But as far as from their side, that's all you got left. And you can tell all of them. You can tell all of them. And I tell you what, for these women right here in the front row, every second you're back there is going to be torture for them. Their stomachs are going to be like this every second. Every minute you're back there. And every minute that you give them back, every minute you give them back and you come back out here and you say you never should have done this, because you've seen all the videos. If you don't need to go back there and watch 20 hours of videos. You've seen them all from every angle. You've seen every possible thing that anybody could show you. The state rested without calling any expert, without calling anybody at use of force. The only person maybe close is Chernak, 32 years. He's had a lot of experience, and he said, I would have done the same thing. He said that we had to go in, we had the duty. They had a duty to go in, they had a right to go home. We're asking you to send them home.
May it please the court. Opposing counsel. Mr. Lunan said something at the beginning of this trial that was accurate, but it wasn't true. And he said it during one of our heated exchanges. We had a number of passionate exchanges, I like to say, and he said it, and it stuck with me. He said, you just don't like the law. And I gave some response, but I thought about it as time went on. I said, David, you know better than that. I worked with you when I was district attorney. I worked with you, Daryl. You know that's not true, but it was accurate. Because I don't like the law. I love the law. I love the law when I was responsible for this table. I love the law when I'm sitting at this table. I love the law when I was prosecuting people and making capital murder decisions. I love the law when I'm defending somebody from not going to prison for their life because the government has gone out of control. I love the law. And you know why? Because for me, the law is our last hope. We live in a world where we can't agree on anything. We definitely can't agree on politics. People have a different opinion about religion. We can't agree on definitions. We can't agree on everything. But most people agree that we should have a system that says innocent people don't get accused and innocent people don't get ripped from their families and their children and not have ability to raise their kids and go to prison. Everyone can agree on that. And that's why I love the symbol of our justice, Lady Justice. I think she's beautiful because everything about her means something. And it goes back to ancient times. The blindfold means that she doesn't look at what your political affiliation is. She doesn't care that somebody is Hindu or Buddhist or Islamic or atheist or that I'm a Christian. She doesn't care about any of that. She looks at the law, she looks at the facts, and she merges them together to find this elusive concept called justice. And the sword. The sword means that justice systems can be harsh. We have capital punishment. We have the right to defend yourself. And as somebody said, something that may look awful, because every self-defense situation looks awful, but it would be lawful. There's no nice way to defend yourself. There's just a justified way to defend yourself. And that's what that means with the sword. And her foot's on the book. The reason why her foot's on the book is because she has to have a command of the law to dispense the law. And as Jason pointed out to you, you're going to hear from Mr. Lunan, from David. I call him David. And he's going to come up here, and these are the men that, thank God, this judge had to correct. They told you things that were not true. I'm not going to look at their intent. I'm not in their head. That's between them and God. But all I'm saying is the judge had to correct them and tell you, discard what they're telling you. That's why I stood up. That's why I had these passionate exchanges. That's why we were laughing and Soto said, this is not funny. It's not funny, Jason said. It's ridiculous. We all know this. There's over 180 years, I'm not saying for any other reason, of experience here. As prosecutors and defense attorneys, and we all knew that wasn't true. They know that's not true. They still argued it. Why? But Lady Justice takes care of that because she has a command of the law. And regardless of your faith or your religion, the universal symbol of a serpent is evil. And our justice system should crush out evil. And that's what she's supposed to do. But, the scales. She has to balance it all out. She keeps the blindfold on. She doesn't do this depending if she's dealing with an officer or a citizen or a carpenter. Doesn't matter to her. She doesn't care about those stupid cameras. She doesn't care about politics. She's got to balance it all out. And what happens in a jury trial, and why I'm so passionate about a jury trial, because I've been through this. I shared with you in Vordire. My family, my brother was here earlier. My parents, when my brother was murdered, We had Terry McDonald was sitting on a bench like this. Judge Mike Ramos today, and Jack McGinnis prosecuted the cases. We had an advocate. I sat in those chairs. I know what it feels like waiting for a verdict. I get it all. I made capital decisions as DA. I've defended people falsely accused. I'm passionate about our justice system, and Lady Justice balances it all out. And in a jury trial, in a system of the people, by the people, and for the people, she takes those scales and she hands them to you. And now you have the scales. And that's why I'm so passionate. And because I'm so passionate, I'm in a dilemma. I'm in a dilemma because, as everybody has said, Mario and Jason and other people have said, because it keeps me up at night. If I look like I haven't slept in 4.5 weeks, because I haven't. Because it wears on me. It wears on me. Did I do enough? Did I argue too hard? Did my passion, that's my strength, if it took it out of control, and did it make a difference and make you look at them differently because you're mad at me? I think about that, and I harbor that in my mind. But I can never apologize. This is my dilemma. I can't apologize to you, Mr. Hernandez. I can't apologize to you. Because then I'd be a fraud. Because then I would be looking at you like these men looked at you, and I'd be telling you something that's not true. So because I cannot apologize to you, I can only humbly ask for grace. Just extend some grace to me. You can cuss me out later if you want to, but please don't hold it against them. And so I told you at the beginning of this trial, this is an upside down world. An upside down world where the government is supposed to wear the white hat. The government is not supposed to be reprimanded by the judge and corrected by the judge mid-trial. The government is not supposed to audible their theories in the middle of trial and see which one sticks and put a bunch of it on the wall and see if it sticks. That's an upside down world. The government doesn't attack law enforcement for doing their duty. The government doesn't try to misuse statutes and tell you something applies when it doesn't. That's not what the government does. The government doesn't bring 0 experts on a use of force case. The government is supposed to rely on a detective who did no investigation, and we'll talk about how that went. That's an upside down world. And where we, as I think it was Christian made the point out, we may seem like the government, although we've served in that role honorably, but we're prosecuting the case for justice. And we're bringing you evidence to consider. And that's why it's upside down. And so at the beginning, if you remember, I went through and all of us kind of went through these 3 scenes. There was 3 separate incidents. And we all mentioned it before. I thought it interesting that Mr. Harris, I was counting it, 20 minutes and didn't talk about use of force. He sat back here, because I was wondering where Darryl went. He sat here and let you stare at a video that had nothing to do with these 3 men. For 20 minutes. We've been here 4.5 weeks. And you played it. So this was not closing arguments, it was closing videos. But about men that aren't sitting at these chairs. So you have to keep those in mind. Because once Officer Salinas is swung at with that hammer, and did you notice Officer Chernak? He sat here, and look, I had notes, and he was being a little stickly at first, which I appreciated. And Jason kept asking him questions. And as soon as for the first time he saw that video, Mr. Autry, he saw that video for the first time. And his whole demeanor changed. I would have done the same thing. If Maria Salinas pulled her gun, it was justified. Everything changed when he saw that video. And once she swung that hammer, unfortunately, at Officer Salinas, other than Ramos irritating the crap out of me, and Rojas maybe irritating you also, that's irrelevant. All of that's irrelevant, because they're responding to an E-tone. All they know is they're an officer in trouble. You heard evidence and evidence from all our experts about an E-tone and what that means. And so that's all that you focus on. It's from this way forward, but they want you to focus on Salinas' back. And it has nothing to do with these men, and they know it. The defense, we brought you 5 experts. We brought you 5 experts involved on officer-involved shootings. You heard from Duke, Mark Duke. I've never thought I'd testify for the defense, but he couldn't sit back. He's a good officer. We prosecuted with him. He did a damn good job every time he did it. And he looked at this case, and none of them were hired guns. It wasn't like we went to him and said, "Hey, will you come testify for us?" You heard from everyone. We asked them specifically these questions. Evaluate this evidence. Let us know your opinion. This is a terrible prosecution. This is a horrible investigation. Will you testify for us? Yes, I'll testify. Every single one of them. Lisa, you heard from Lisa. Well, I'm going to talk to you what the government brought you. You heard from Lisa. We're going to talk about Butch. I'm going to show you some videos from how Lisa testified. Sergeant Miller testified. And then Lieutenant Butch Majeka. and then of course Dr. Martinelli. So they brought you one. Who did they bring you? Soto. And they had the audacity, David had the audacity to ask one of our experts, well, Soto has an opinion, doesn't he? Some of you laughed out loud. It was not fun. It's ridiculous. What I'm asking you as we go through is, don't Soto our San Antonio. What does that mean? Don't let Detective Soto be the standard for investigations for homicides. Don't let Detective Soto be the pillar that they rely on to prosecute men and peel them from their families. Detective Soto, I stopped counting after 22. That's why I put 20 plus. On how many times you said, I assume. Where's that in the penal code? Soto assumes. It's nowhere in the penal code. None of our experts said they assumed. They looked at law, fact, and even science and applied them appropriately. I didn't think. He said that many times. I put what I needed to get probable cause. That's not your goal. You put what you needed to. We're going to talk about his testimony, about him making a decision, and then that meeting with Brass. And then remember, nobody brought in Captain Van Geffen. And then remember, Captain Van Geffen, who did he meet with? Who did he meet with? Mr. Harris. Remember that? In fact, so maybe we should have called him as a witness. Because we made that. You heard that testimony about that. We'll talk about that. I'm willing to concede I did not write it correctly. He said that about numerous things. His prosecution guide, his affidavit, to the warrant, to the arrest warrants. He said that numerous times. I did not consult, listen to this one. I did not consult any use of force experts. They did not consult. They did not call any use of force experts. None of them took that stand. None of them took an oath. None of them subjected themselves to cross-examination. None of them. I put in what I thought was relevant. How convenient. What you think is relevant? How about I tell you what I think about what you think is relevant? And we did. And it came out in court. Look, we're in a situation, folks, where we were up all night just thinking, what do we put in closing to remind them? Judge, I'm going to need some more time, Judge, with all due respect. They can have an hour, Judge, if they want it. So what I thought was relevant. What you think is relevant, Detective Soto? I don't know what exculpatory evidence, and I think Mario mentioned that to you. That's just bare minimum. Everybody, every officer, not even a detective, everybody knows what exculpatory evidence is. Every prosecutor, paralegal, everybody knows. Advocate knows, but he didn't. I just looked at whatever I saw on body cam. That's the extent. I didn't interview anybody. I didn't interview people in front. No one called Maria Salinas. Remember we said at the beginning, if you have any questions at the end of this trial, who owes you the answer? The government does. The government that Thomas Jefferson was talking about, the government, not three individual officers, the government, the apparatus of the government, the ship of the government. And this is what he saw on body cam. You heard experts talking about that. Angelos talked about this. That was our fifth expert. He talked about how the human eye versus the body cam and how it looks and how it's lower versus the eye level. And they were trying to say, well Soto said that when Maria Salinas, I didn't see him swing at Villalobos the first time. But she's talking about it. Vince Gomez, who they didn't call, talked about it. Officer Young, they didn't call. Where's Sergeant Rivera and Sergeant Robertson? Sergeant Flores wasn't the only sergeant at the scene. This wasn't his plan. Where's all these people? But they called Chernak on the side. They don't call Ramos. I don't blame them. It's embarrassing. They call Rojas, who Rojas on the stand. I had to stop him. He admitted, because he was so delusional from what they were telling him during pretrial, he admitted to burglary rehabilitation. Do you remember that? And I said, you didn't do that. Stop. He admitted on the stand under oath that he committed burglary rehabilitation. He was a party to it. Insanity. And that's why you saw passion from this table. That's why. But this is the reality that our experts explained to you. They could have done this. Butch Majeka, 47 years. Here's Butch. He's still prosecuting cases, helping prosecute cases. He works in Kendall County. 47 years experience. He's been involved in prosecuting police officers. He's not a hired gun, because no disrespect, Ben, but if you think a Happy Meal is hired gun, he's here for free. He's been here with you, sitting in that corner. You've seen him for 4.5 weeks, taking vacation time. They would have you to believe that Butch Majeka and all of the other officers that have impeccable reputations want to throw it all away in public for the nation to see, just so they can save officers that are really guilty, that they don't believe the testimony they shared with you. That's what you want them to believe, David. That's crazy. He's going to try to push that to you in a second. All officers, listen to this, all officers. Villalobos, Alejandro, Sergeant Flores. All three officers were justified in using deadly force at the time they used it because it was reasonable and immediately necessary, Chapter 9, to defend themselves or a fellow officer from Melissa Perez's unfortunate, he didn't put that, I'm putting that in there, unlawful use of deadly force against them. Sergeant Miller said the same thing. Mark Duke said the same thing. Dr. Martinelli said the same thing. No rebuttal evidence. Nothing. The cross-examinations fell flat because they don't have the truth on their side or the law. Play this for you really quick. How do you play it? Sound should be on. There we go. So again. Thank you, brother. You just back out of it? Okay.
And in Graham v. Connor, does the court admonish the reader and judges that you must put yourself in the perspective of a reasonable officer on the scene?
It does.
And in your review of this case, did Detective Soto fail to put himself in the shoes of Alfred, Eleazar Alejandro, and Nathaniel Vilobos?
He did, and he admitted he did.
All right. And is that a violation of the directive in Graham v. Connor from our Supreme Court of the United States?
It is.
All right. And did the Supreme Court of the United States admonish that you must put yourself not only in the shoes of the officer, but you cannot judge them with 20/20 hindsight?
It does.
And did, in your opinion, your expert opinion, did Detective Soto attempt to judge them with 20/20 hindsight based upon his assumptions?
He did, and he admitted that he did.
Soto didn't follow the standard. He talked about what the standard is. You heard about case law and what the standard is, that you're supposed to review the situation from the view of the actors. That would be these three officers, these good officers there. He didn't do that. And he looked at it from hindsight, which the Supreme Court said you don't do. The experts said nobody does, and detectives aren't supposed to. And he regretted it. And while he's putting this up,
Judges look at the evidence before you walk the warrant on them for murder. You might want to take more than 12 hours and review some of these things before you had them arrested and put on the news all over the country and their mugshots for murder. Do you think you might do that in the future, knowing what you have experienced here today?
There are things I could do differently, yes, sir.
Okay. I'll pass.
I'm going to play this, keep playing. I want you to watch the way he leaves. I want you to watch how he gets off the stand.
No questions, Your Honor?
And you said no questions, right? No questions, Judge, thank you. All right. Never mind, gathering.
Watch. I'll spare you from what I whispered in Jason's ear. But in all of our years in that collective table, we've never seen a witness, especially a lead detective, sneak out the back. And you know why? Their investigator, where are you at? Where's their investigator? He was waiting for him at the door. Because every witness goes to the investigator and walks out the back with them. And he left him hanging. Why? Because he couldn't. Detective Soto couldn't look past you. He didn't mind sitting above you, but he couldn't look eye to eye with you and say, I'm proud of my investigation. He couldn't look at these family members, especially the mamas here, and say the same thing. He couldn't look at the same cameras that he didn't mind dragging them in front of nationwide. Helping drag in front of nation. He didn't have the integrity or the courage to look at those cameras and these family members and say, I'm proud of what I did today. He snuck out the back. They've never seen it. Their investigator was waiting for him, and that's why you saw my reaction right there. And I will spare you from what I told Jason.
I tried to look.
Then you heard about beanbag, taser, and shield. We talked about that. I specifically asked Butch about that. The beanbag wasn't practical, and it's not less than lethal. Within 21 feet, it's lethal. So Sergeant Rivera would have been sitting right there instead of Sergeant Flores if it was switched like Jason said. And the taser is a compliance technique. Every expert testified to that. Even Chernak talked about that. Their witness talked about that. It is not a self-defense technique. You don't use that in self-defense against deadly force. And then the shield. You saw my demonstration with Jason. And we even, it's in evidence. Not that you need to see it because you heard Butch talk about this. You had the curriculum. We put it in evidence. That shield is not made for that, is not designed for that purpose. And I gave you the demonstration and why it wasn't, and why Sergeant Flores still considered all of it. And then with Sergeant Rivera and Sergeant Robertson and 13 other officers, this was their plan. It wasn't his plan. They implemented a plan the best way they could. And she changed the situation, not them. She changed it, unfortunately. And then we heard from Daisy Nieto. I don't know if she's in the audience or not here. But can I tell you that I wish and I would pray that everybody has a sister-in-law like Daisy Nieto. What a precious lady you were. I don't know if she's in the audience still. But I liked her. We all liked her. She was a blessing to Melissa Perez. She's a blessing to Dylan. And you don't have to believe me if you don't want to. I told Jason driving in here, I thank God that she has Alexis and she has her tia. I don't know if they call her tia or not, her aunt, Daisy Nieto. And what did she tell us though? She was honest. What an honorable woman. She was honest. Melissa whispered into her, and unfortunately, I'm sorry, I hope he's not watching this, but this is the reality that you have to consider. She whispered into her boy's ear, I'm going to kill you, and it scared him. This came from Daisy. Told you Melissa would randomly and violently attack strangers based on her delusions, from her neighbor to the bus, and unfortunately, Dylan had to see that. They saw all these things. And she eventually made a healthy separation between her and Melissa. And I say that unfortunately because that's hard. Everyone has to. My mom had to do that with my uncle Eddie, unfortunately, my Uncle Louis. We've all been through stuff like that. But Alexa stepped up and she has two toddlers like Daisy said, and then now she has Dylan. What a blessing, right? So I hope she'll shake my hand after, but what if this woman is a woman of honor and she told you the truth about her sister-in-law. Wanted to know if, and listen to this, she wanted to know if the old man, if the officers were okay. That was her first thought. Not that someone hurt Melissa illegally. She knew what they had been dealing with, what the whole family had been dealing with, unfortunately. They had to have a healthy separation. They hadn't talked to her for 5 months. And she had the honor to ask about the old man, Mr. De Los Santos. She didn't know his name at the time, and the officers. Lisa Miller.
Do you know who Officer Pedraza is?
Yes, I do.
Who is this gentleman?
He was the sergeant in charge of tactics and shooting at the police academy at the time that the shooting occurred.
Did you have an opportunity to talk to Sergeant Pedraza?
I did.
Did your conversation with Sergeant Pedraza help you form your opinions of not only Detective Soto's investigation, but also this prosecution?
It reinforced the conclusion that I had already reached, yes. Disturbingly so, yes.
What was disturbing about your conversation with Sergeant Pedraza?
That he was called to a meeting at the chief's office between 8:30 and 9 the morning of the 23rd, and that the administration had already made the decision to arrest the officers. That was like 2 hours after they finished getting statements from the officers. The decision had already been made to arrest them.
Did they give him any instructions or any perceived threats to Sergeant Pedraza?
Yes, he disagreed with that decision, and he was told to keep his mouth shut if he wanted to keep his position at the academy.
Every sergeant Lisa Miller talked to, and she did the investigation that should have been done, said that these officers were justified. Lisa Miller did the investigation, Detective Soto was. Why? Because she wrote the curriculum on homicide investigations. She's not making this up. She wasn't flying by the seat of her pants. She told you how she trained other detectives. And so Daryl knows we bring Thomas Jefferson up because we brought it up in voir dire, so he knows that, jury selection. And I can't say this enough as I start winding this down. Jefferson said, I consider trial by jury as the only anchor. And Jason gave you that example. That means something to us, that anchor, ever imagined by man, by which the government can be held to the principles. One of the principles that nobody talked about was due process. You know what that means? Fundamental fair play. Every one of us, they also have the right to fundamental fair play. And you can't tell someone we're going to hold you responsible for breaking the rules when they break the rules themselves. And that's why the jury process is so sacred to us, and it should be sacred to you. And that's why the power is in your hands. And the only thing I agreed with Daryl, I'm going to call him Daryl, not to be disrespectful, but Mr. Harris, during opening statements, he told you this during closing. He said this, you are the ones who put a check on the government. I agree with you, Daryl. I agree. You're the only ones that put a check, a true check on the government to make sure that they have not flown and floated out of bay, that you can pull them back with that anchor, the anchor of the Constitution, the anchor of your verdict, and tell them this is not acceptable and this is not the standard. We're not going to Soto our San Antonio, and you cannot do an investigation or a prosecution like this and expect us to be your puppet and to punish innocent men. Here's the hardest part of my job now, because I have to sit down. It's tough for me. That's going to be hard, I promise. It always is. And because the way our system is set up, because they have this double burden, because they have to prove that they're guilty beyond a reasonable doubt, and then have to disprove, and you've heard no evidence to disprove self-defense beyond a reasonable doubt. Not even probable cause. You've heard zero evidence to disprove self-defense. They have that burden, that double burden, and so they start with you in jury selection. They open first, they do their case in chief, they close first, and so we get the Malachi Crunch, if you watch Fonzie. They get to sandwich us in. And we have to sit down and listen. You're going to see me sitting there, and my leg's going to shake. And I'm going to look down, even though I hope you give David your attention. But I'm going to be writing notes. And just think to yourself, what would Nico say, or what would Jason say, or what would Ben or Mario say, or Tom or Christian say? Because I promise you, there's nothing, and I say this respectfully, there's nothing, zero, zilch David's going to say that doesn't have an objective legal answer to, and a practical one as well, I promise you. But I can't talk right now. And they're going to say, no one is above the law. I promise you he's going to say that. And he might adjust right now because I just checked him on it. But no one's below the law. Should have been a different plan. Based off whose testimony, by the way? David, this is not testimony. I'm winding up, Judge. This is not testimony. Based off whose evidence does he want you to depend on? You're not going to talk about a witness that you brought. He definitely didn't get it out of one of our experts that are normally their experts, by the way. Should have used less lethal. Like what? Take me to the chapter 9 and tell me where that standard is, because it's not. You can't resist arrest. We talked about that. It's all in the charge. And he's going to be asking you to do things that are not in the charge. And as Jason pointed out, and other people did, they've already had to been corrected. And thank you for pointing that out, Jason. Remember, respectfully, but I got to call it out. He asked you to do things that are not right, that the judge had to correct him on. So keep that in mind when he gets up and talks with you. And he's going to say, send a message. That goes both ways. Send a message to them that the chief and the district chiefs and the deputy chiefs and the assistant chiefs can't make a decision 6 hours after an event without looking at anything. Audit trails. And then you can't have the captain in that meeting meet with Daryl Harris, and then they make the decision. And then you can't put up Detective Soto to tell you under oath, so I don't know if they're going to be evaluating that for aggravated perjury. I don't know if you're going to do that, David. But he obviously testified improperly under oath. And he said he made the decision. That all can't be true. They brought you no evidence. We brought you the evidence. We're prosecuting a case for justice. How about that? That's what we're doing. And so when he does that, you can ask yourself, what evidence did you prove to me, David, Mr. Lunan? And the answer is none. We brought the evidence to you. And when you apply that standard, and when you do all that, and when you think about the consequence of this, because the consequence is twofold. There's a personal one, and there's a societal one. Because the message you're going to be sending to those cameras and all these people is, it's open season on law enforcement. That the law enforcement can't do their job, and you can use deadly force against a police officer. And if you can use a deadly force against a police officer, unjustifiably, and the judge told you it was unjustified, it's in the charge, nobody's safe. it's going to turn into Gotham, right? We're going to be policing ourselves. Survival of the fittest. That's the message you'll be sending, whether you mean it or not. But that's what they ultimately want you to send. He's going to say he doesn't want to, but that's what's going to happen. So send the message that you can't bring Soto. You can't have a decision from the top within 6 hours. It normally takes months and months. You can't not bring experts. The experts that they should have had testified for us. And you can't use people as puppets. And we're not going to be your puppet, guys. And you know how you say that message? You say, with respect, but quickly, God willing, quickly, you come back with a verdict of not guilty on all of them. All of them not guilty. God bless you and thank you for putting up with me.
We just need a couple minutes to set up. Okay.
Judge, can we get a few minutes to rearrange?
Want the jury to take a quick break?
Yes, sir.
Let's give you a quick break.
All right,
Welcome back, members of the jury.
Thomas Jefferson's been quoted a few times today. I've got one more for you. Last one, I promise. It's the measure of a nation's greatness is how it treats its most vulnerable members. It's been attributed to Thomas Jefferson. Mahatma Gandhi has said it. Hubert Humphrey, of all people, have said it as well. This notion that a country must look after its most vulnerable people. And Melissa Perez was one of our community's most vulnerable people. And her mental health challenges were not her fault. Despite our well-intentioned laws, she did not get to ever see her daughter graduate from nursing school. She didn't get to see her son turn 18 years of age on an incident that frankly should not have happened to her. Should not have been treated that way. You know, they remarked that her family had called SAPD a number of times before when she was in crisis, and it all handled where she surrendered, didn't resist, and they were able to take her in and get her into inpatient treatment or those kinds of things, and it didn't come to this. But she didn't have those same officers respond this time. There's a lot of discussion about Detective Soto and his botched investigation. Well, Detective Soto was not assigned to the investigation of the criminal mischief. When I had asked former Detective Mark Duke about what failures Ronald Soto had in this investigation, that was the first thing he went to. Well, he didn't get DNA off the door, and he didn't do pry marks on the door. And what were we going to wait for all of that? That wasn't what his assignment was, and it wasn't necessary for another officer to do a investigation into the criminal mischief after she was dead. So I just thought that, and then the other complaint, because I'd asked him, they used these horrendous and horrible and what a terrible job that he did. And it was the first time he ever did an officer-involved shooting. It wasn't his first time as a homicide investigator. It was his first officer-involved shooting, not the first homicide case he investigated. And when I asked, what is it he didn't do? What is it he didn't do? I mean, he attempted to get all the casings. He did get all the casings. He got the video, the person who did the video there, who collected all the evidence. He's got the follow-up with the autopsy and with the ballistics exam and all those other kinds of things that he did. What he failed to do is he failed to personally interview all the people there were at the scene, even though all of them gave statements. Okay? What he did get for you, and what's the most important thing, which is so unusual in a criminal case, is he brought you everything from the time police had contact with Melissa till her death and thereafter. Everything that they said to each other, everything that they saw, they observed, they experienced, all of that is available for you to determine whose actions were reasonable or not. Titled this Monday Morning Quarterbacking. I want you to consider the number of exaggerations and invented reasons that have been offered by the defense for the reason why Melissa Perez was shot in her home. Let me just go over a few of them. You remember this in the testimony. This goes back 3 weeks or so. But the fact that she had lit candles in her home, that perhaps they perceived that as the danger and the urgency to move in. Do you remember that? Do you remember those conversations? That she had, that the neighboring building no longer had working fire alarms. So that was the urgency of why they had to go after her then. Wouldn't have changed the fact that the neighboring building didn't have working fire alarms. They suggested to you that Melissa was perhaps planning to set fire to that apartment building, and the cutting off the fire alarms was just the initial step in that process, without any evidence of that whatsoever. In fact, if she was planning on setting fire to that building, do you think she would have gone to the fire department and the police officer and said, "I'm the one who did it. I'm proud that I did it. The voices in my head have minimized since I've done it," right? It's an exaggeration to demonize her. And you know, they talk about it and saying they're concerned for her, and they have these feelings about how unfortunate it was for her. But they spent all their time demonizing her unnecessarily because those officers did not know all those kinds of things. Officers were looking to find evidence of a criminal mischief in her apartment. They spent a lot of time on that. They weren't. You can read from their statements. You can know from watching all the video and all the conversations they had and all the planning that they engaged in. They weren't looking for any evidence of any criminal mischief in her apartment. So then why did they bring that in? Why did they bring in the batteries? Why did they bring in those things? To demonize her. Again, to make her look bad. Santos de la Rosa in the back bedroom was at risk from her unpredictable behavior. I hear this. It's in Alejandro's statement, right? Saying that we had to go in because there was this man here in the back bedroom that was subject to being hurt by her. Well, no one, and you can watch every video. I suggest you kind of go through and look through Rojas's video or so. They had one conversation with him, and Rojas comes to the window. This is before all the other 14 or so show up. And he asks him, "Will you let us in?" And he says, "Look, I'm here in bed. I really can't get up." Nobody expresses any concern for him. Nobody sees. He's actually very well cared for, if you'll see, in that situation. He's got kind of a medical table there. He is, from the other evidence, she picked him up over a month before, and that she had provided safety and security and food and medical care for this man. This man was not in danger from Melissa Perez. He was probably being kept alive by Melissa Perez. We heard by the evidence he died a month later, 3 months later, when he was sent out to the homeless shelter. They insinuated that the fluid in the cup sitting on his window ledge had to be urine. I mean, Officer Rojas says, I don't know, it looks to me to be Gatorade. But no, they were insisting that this was proof that this man was not well cared for because he had urine in a glass on his windowsill. Again, an exaggeration, unnecessarily so. Throwing the prayer candle at Officer Salinas was deadly force. It was not. It was not. It was force. It was unlawful. She should not have thrown a candle at him. But, Officer Duke testified how precisely she threw it with the accuracy of Nolan Ryan or whatever it was, right? She hit him here in the elbow, right? Or just on the forearm, the left forearm or so. This was an application of force, not deadly force, and that's important. Suggesting that Ms. Perez was especially skilled with a hammer because one of her many jobs over the years was as a roofer. Again, they jumped that to that she has this regular activity of using a hammer. Roofers use nail guns is what they use, and they do a lot of other things besides taking a hammer on roofs or so. And it was just one of the side jobs she had. It didn't make her a roofer. This suggestion we heard from the very beginning that Melissa Perez attempted capital murder of 5 officers. I didn't see it in there. Maybe you guys can go back and find out where she attempted to kill 5 officers. I didn't see it. What I saw is a woman who is trying to keep officers out of her home and away from her. That's what I saw. I did see her throw a candle at Officer Salinas, and you saw that. And that's not a attempting to kill someone. That's an attempt to hurt somebody, to push them away, to get them away from her apartment. That they had to make a split-second decision. These officers didn't make a split-second decision. Melissa Perez's conduct was entirely predictable. Why? Because she engaged in the same behavior over and over again when they tried to enter her apartment. When Jonathan Salinas tried to go in, she rushed at him at the window. And he came back and still from within inside her patio wouldn't leave, pulled his gun on her, and she threw the candle at him. When Officer Villalobos tried to enter in, she rushed toward the window, and he backed out. And then she stopped, and you can see Officer Villalobos standing there, unafraid, kind of going, "What's up? Why are you guys wanting me to get out of the window? I know she's got a hammer. We've talked about it before I went in. I'm in a safe place here with my foot on the door, behind this wall, behind this door of windows." And then he gets out of there, and you can hear him say, "I'm not afraid of that hammer." Well, he didn't say hammer. "I'm not afraid of that," right? "I'm not worried about it," right? Because he wasn't. That they had this duty to go in right there and then. That they had to go into her apartment right there and then. And then they criticized Officer Soto for getting a warrant just because he had reached the threshold of probable cause, 16 hours later. That Soto, Detective Soto, gave those officers 16 hours before he decided to take some action against them. They waited, or Sergeant Flores waited 15 minutes before he decided this needed to happen. Arresting someone is a far cry from engaging someone in a deadly game of chicken, which is what ultimately this plan was. More exaggerations. Well, I'll come back to, why that they actually entered her apartment. And Alfred Flores told you that right from the beginning when he confronted Melissa at her patio window, and he tells her, "You assaulted one of my officers. We're going in. We don't need a warrant. We're going in." That's the only reason they went in. It's not any of the other reasons, the lit candles, the concern for fire safety, the old man in the back. That's the reason they went in. And it's kind of a bravado thing. You did this to one of my people, we're going in. There's no getting away with it. We know this to be true.
Come on here and talk to us. She's committed. I know, she's right there, isn't she? So we tried to kick all the doors. Yeah. So I'll try to fucking window. We tried to start throwing her. She took that and she grabbed the hammer. I have the hammer. You got a hammer. Where's Thompson? You put that air shield in the camera. You said somebody's door that was out of work. That's not a warrant. So she's committed. I know that she's right there. So we tried to kick out the door before they can't. We tried going in the window. We tried that and she started throwing she threw that and then she grabbed the hammer. I had the thing with the hammer. Yeah, because you tore my door down with no warrant. You don't take somebody's door down without a warrant. Just door down. Melissa, come on here and talk to us. No. She's committed. I know, she's right there, isn't she? So we tried to kick out the door before they can't. I'll try to fucking window. We tried that and she started throwing she threw that and then she grabbed the hammer.
So what we hear from that is Villalobos, when being told about the hammer incident earlier, is he's saying, "Where's that shield? Where's Thompson again? We've got that shield, available to us." His first thought he came to when he heard about the only weapon that Melissa had shown that she had. So, in the totality of circumstances, let's consider what we know from the evidence without the exaggerations. Put the exaggerations aside and start looking at what we actually knew, or what these officers actually knew at the time. Not other officers, but these officers knew. So what did Flores know? He knew that Ms. Perez had cut the wires to the fire alarm. Now, that may seem not to be very significant or so, but when you think, who cuts wires to a fire alarm, right? That's actually a clue. Who would do that? What kind of person, what would they be going through to feel like they had to cut their wires to the fire alarm? This isn't something people do for profit, right? This isn't something people do for fun. It's something people who are having issues do. So anyway, that's a clue that he knew. Secondly, that she was repeatedly claiming that cameras were everywhere, that all America was watching. We heard this over and over again, right? These aren't the claims of a person who's well, okay? It's a clue that was ignored by the officers at the time. That she quite clearly believed officers had no authority to enter her home. Do you think she believed it? Absolutely, she believed it. She said it, I don't know, 50 times perhaps during that encounter, right? She believed it. They had no authority to go into her home, that they needed a warrant. And when you're confronted with somebody and considering the potential for mental illness and the complete defiance of that, you have to approach this in a sensitive manner, and they did not. That although her front door was locked, all of her windows were open, screens could be taken off. They were completely unobscured into every room, and there was a lot of space, right? We saw the room next to the patio. We saw the room next to that with the bunk bed. We had other windows to that same room around the corner, and we had her bedroom thereafter. All the windows are open. That in the 2 hours that officers had contact with her, she displayed no other weapon but the hammer and a candle in her hand, and that she had threatened to hurt no one, and that she attempted to hurt no one unless they tried to go in through her door or her window. They could see how her size, her diminutive size. They could see that there was an old man in an adjoining room. They knew that they had multiple tasers. They had 15 officers present. They were well trained. They had a shield. They had bulletproof vests on. They had a shotgun was available for the rounds, for the beanbag rounds in it. They knew, of course, that she had thrown the glass candle at Officer Salinas. That's the reason they all came. We know that when they were told to slow down, they did not. If you've watched their body-worn camera, it did not cause any of them to slow down. That she was behind a window, partially obstructed by a TV, a solid wall, and a glass-paneled patio door. That's the reality of it. They were outside, she was inside. He was told the patio door was unlocked. This is Sergeant Flores, right? He's told the patio door is unlocked. He chose not to wait for a key for the front door, even though he did just minutes before talk to Kenji Uno, who said, I can get one, and tasked him to go get one. He decided not to wait for that. But they chose to attempt this entry while Miss Perez was looking at them, right? Was standing at the window looking at them. They didn't try to attempt this entry while she had wandered off to another room or anything like that. She was within 3 strides of where the hammer was. What did Eleazar Alejandro know? Well, he knew, again, the comments about the cameras being everywhere. That she clearly believed the officers had no authority to go into her room. He had known about the thrown candle at Salinas. He knew that other officers were saying that Nathaniel Villalobos, that she charged Villalobos with a hammer in the window. He knows, because he was present there, to hear Villalobos say that he wasn't afraid of that hammer. He could see from his positioning that Villalobos could stand there and prevent that door from opening with his foot. He knows that the only weapon she displayed was the hammer and the candle. He could see her size. He knew there was an old man in the back bedroom. This expression about saying, chick's crazy, and I welcome you to look at his body-worn camera and the other body-worn cameras to feel comfortable in your mind about who actually makes that comment. It's Alejandro who says that the chick is crazy. But you can listen to it. You don't have to hear it from the statements of lawyers. You can make that determination yourself. But I think it's important for you as a community in judging the officers' conduct and their reasonableness and deciding what would an ordinary and prudent person standing in that position have thought. Is the fact that this is a mental illness issue important? Does it require us to take additional time? Does it require us to give certain other considerations than they gave Melissa Perez in those 15 minutes? She's behind a window, obstructed by a TV. She's told, he is also told the patio door has been unlocked. They choose to attempt entry while she's watching them. Vilobos knew many of those same things. He personally felt like he had unlocked the window or the door to the patio. He had told others that he was not afraid of the hammer. And all those other things that they knew, he also knew. We had put that he had believed that he had unlocked that door. But Nathaniel Villalobos, before he fired his 3 shots there in the end, when Melissa was behind the wall, you can see him on 2 occasions approach that door and unable to open it. He knew at that time that he fired those 3 shots that door was locked and it could not be opened. He had attempted twice to open it and could not before firing those 3 shots at her unseen. He admits as much in his statement. If you look at his written statement, he'll say that he checked that door and it was locked. What Flores, Alejandro, and Villalobos did not know or seek to know was anything about her mental health, diagnosis, or history, anything about her prior arrests and emergency detentions, anything about any risk to the old man in the adjoining bedroom, anything about the harassing behavior of officers that occurred prior to them getting there, and that the apartment contained any evidence of criminal activity. These are things they didn't know, they didn't consider. Perhaps if they had stepped back and evaluated the situation more clearly in the totality of circumstances, those factors, the answers to those questions, would have led to a different course. Self-defense, use of force. It's in your jury charge. You'll see it. You probably are experts. You probably teach the subject by now, right? It says the person is justified using force against another when and to the degree the actor reasonably believes the force is immediately necessary to protect the actor against the other's use or attempted use of of unlawful force. Why I've kind of broken it down there is to kind of show you that this reasonable belief goes to a number of factors here, right? It goes to the when, right? The timing of when this force is used. It goes to the degree, the how much force is necessary, right? It goes to whether or not the force is immediately necessary to protect the actor or another, we've got the defense of another, against the other's use of unlawful force against them. This reasonable belief is not what the officer believed. It's what an ordinary and prudent person would believe standing in the officer's shoes. I think we've made that abundantly clear throughout this trial, right? And that may not have been something that was commonly known, but that's perspective. And why is that? Why is that? Why is it that the law and our tells us that we don't just take the person's own view of it as gospel or as definitive or as conclusory? It depends on people like yourselves who are citizens, who are faced in those same circumstances. Is this the proper thing to do? Not what a hot-headed person would do, not what an insane person would do, not a person who has any motive or bias. It's what an ordinary prudent person would do. And we talked about prudent, and I had Butch on the stand or so, and he agreed prudent is kind of a careful person, right? Ordinary, careful person. What would they do faced in those circumstances, perceiving what the officers perceived at that time? Use of deadly force, right? So the difference between what your authority to use between force, right, which is action not likely to cause serious bodily injury or death, and deadly force means you're utilizing force that is capable of causing serious bodily injury or death. Right? So here it says it's the same things, right? Before you use deadly force against someone, you have to be confronted with deadly force. Okay? The person you're seeking to protect, you have to have a reasonable belief that they need your protection from someone's unlawful use of deadly force. Not force, but deadly force, before you can use deadly force to protect them. the defense witnesses. So you heard from a number of people that are former law enforcement or present law enforcement. And what do we know about all these people? They are heavily incentivized in perpetuating a system where officers are not second-guessed. Okay, I get that. If you remember from their testimony that they were paid for their testimony by an organization called CLEAT, Combined Law Enforcement Association, something. CLEAT, right? All of them were paid quite well, right? This organization or this union amasses money to help defend officers and pay for experts and those kinds of things so that officers as an institution are protected against being second-guessed. It's kind of like having calling people as witnesses who are on the same team as their clients, right? The people that they had come testify to the reasonableness of their actions are people that are on their same team, people who are incentivized to protect the institution, being a police officer, from being second-guessed. So I ask you to keep that in mind as far as what their perhaps bias or implicit bias is in giving the opinions that they gave. This is a picture, kind of one slide from that entire program that shows you in that third volley of shots that Melissa Perez had already succumbed to her injuries, not passed away, but collapsed behind the wall there, and there were still 4 shots fired at her in that position. 1 by Alejandro, 3 by Villalobos. Dr. Martinelli's testimony. I talked to him about this threat assessment training that he does. And he talked about his 5 rules, right? And his first rule he talked about was not becoming emotionally captured. And so when an officer is preparing to be in a stressful situation, they have to guard against this dynamic of becoming emotionally captured where the endorphins and stimulants from your body and the adrenaline comes in and leads you to engage in bad judgment, right? And he talked about this is a real thing that officers are taught about, and they have to prepare themselves not to have that happen to them, not to be captured emotionally, so that they continue to keep a clear head when they're engaging in a situation that could be life or death. He talks about Rule 2 when approaching a threat like this, and remember he was talking about this in the sense of these high-risk entries that he was involved in, is you consider how can you manipulate your environment, right? Because the goal ultimately in making it a high-risk entry is that nobody's hurt, right? That nobody's hurt. Several witnesses told you that. That's the goal. Officers not hurt, the subject not hurt, right? So what can you do in approaching these situations to prevent that from happening? Well, the thing he suggested was manipulating the environment, right? What can you do in assessing your environment? Take steps to make it so that you don't have to be put in a situation where you got to shoot somebody, right? Can you push a TV over and open up an area where you can tase somebody? Can you try taking a screen off a window, right? Can you, in a situation, take a shield and put it up against a glass? Things that you can do in that environment so that things can be done more safely. He talks about Rule 3, being able to safely accomplish the 5 components of an arrest. Before you go in, see to it and visualize and know that you're going to be able to enter, get your hands on the person, cuff them, place them in under arrest safely. So before you enter, when you take that action. He talked about avoiding time compression. That's probably not an expression you guys used before this trial at all, right? But you understand time compression now, right? Avoid putting yourself in a situation where you would have been forced by moving towards the person that a split-second decision will have to be made. If you can avoid doing that, then avoid doing that, right? And distance and cover are your friends. In this circumstance, they had time, they had distance, they had cover to make this so that it didn't have to turn out in the unfortunate way that it did. And they didn't choose to do it in the 15 minutes that they formulated their rudimentary plan, as Dr. Martinelli called it. I would think when conducting a high-risk entry, somebody who does not want to come out, that you'd want more than a rudimentary plan. You'd want a carefully laid out plan that sought to establish the goals that you had of nobody gets hurt in this instant, rather than let's throw this all together and jump on in quickly. He talked about, I think he spoke on it for 5 or 10 minutes when I asked him about lethal or non-lethal or less than lethal options available to officers making a high-risk entry. Remember, he talked about all the different things, all the different gadgets, the electronic, the chemical, the shields, the beanbag chair, the beanbag rounds, and all those other kinds of things that officers are trained to use, that are available for them to use, so that when they go into a situation where they need to apprehend someone safely, that they use the full panoply of all those devices so that the mission is accomplished successfully, like this one was not. A big part of his argument in his conclusion that he admitted to was that Melissa Perez, he said, was a goal-oriented assailant, and that he assessed her goal as killing a police officer. And the reason why we showed you so much of the video from earlier in the opening of our close is to show you that Melissa Perez's goal was not killing a police officer. Her goal was keeping people out of her apartment. Okay? It may not have been an accomplishable goal. It may not have been a rational goal. It may have been a goal that ended up costing her her life, her reluctance to. But her goal was not to hurt somebody. Her goal wasn't to kill somebody. And the fact that he took that for granted and didn't consider that her actual goal was to keep out of her apartment affects all his conclusions, I believe. That's for you to decide. When you remove the exaggerations and you look at what you saw, because you can see her actions the entire time of what her actual objectives were and what her actual goals were. She wasn't looking to hurt anybody, just like the officers weren't looking to kill her until they were, right? Her goal wasn't looking to kill anybody. It was to keep people out of her apartment. And she was ill. And they set up a situation where, again, it was a fatal game of chicken. Imminent danger requires proof of intent, all right? So it requires proof of intent, ability, and opportunity. And what I mean by that is, in order for that person to be an unlawful threat to the officer, they have to demonstrate that their intent is to cause harm to the officer, okay? That they have the ability to do so, and that they have the opportunity to do so.
This is not the charge. This is beyond the scope of the jury instructions. Overall.
And that they have the intent to cause harm, that they have the ability to cause harm, and that they have the opportunity to cause harm. Okay? I asked Dr. Martinelli about that, and he agreed. He agreed. That's really what's necessary for a person to have a reasonable belief to use force or deadly force against another person. Now, looking at those factors as they relate to Melissa Perez, did she have the intent to cause serious bodily injury or death to the officers? And I've told you, and to focus and remove the exaggerations, remove she missed Officer Villalobos by that much. You can see in the videos nothing about her swinging, taking any action at Villalobos when he's leaning in that window. Look for it yourself. You can see 3 different angles. She charges at him in the window, and he backs out. She doesn't threaten him with a hammer. She doesn't swing a hammer at him. You know, they talked about, well, Melissa Perez, you know, she's going like this on a body-worn camera. That means, again, another exaggeration, that means that hammer was that close to Villalobos' head. There's no evidence of that. And then when Sergeant Miller, retired Sergeant Miller testified, she said, she talked to Melissa Perez, and she talked to Maria Salinas, and Maria Salinas confirmed for her that this meant I was that close to shooting her, not anything about the exaggerations that we're told about. So consider when you're looking about that what Melissa Perez's intent was, okay? What was her intent? when she came at the charge at the windows, like she had charged the windows so many times before. And then you consider what her ability was. It was her ability to cause serious bodily injury or death. And this hammer's been picked up, it's got lots of fingerprints all over this hammer right here, right? But what was her ability with that hammer, given her size and her location? Perhaps she could have swung that hammer if she got close enough to somebody, right, to hurt them, right? There's a sharp end on it, a hard, blunt end on the end. I'm not going to dispute the ability of a person in close quarters to cause serious bodily injury to death. But then it comes down to the opportunity. Did she get into enough close quarters with somebody in an area that was not obstructed where she had the opportunity to hurt an officer seriously with this hammer? I suggest to you that she did not. She was behind a door with framed windows. She was behind a wall. And when Officer Villalobos and Sergeant Flores went across that wall, they didn't have their guns drawn. They were confident that they were in a safe area of that porch when Melissa Perez made that charge and Officer Alejandro overreacted and started shooting at her. Okay? And that kind of what prompted the others to react and respond. But they did not fear serious bodily injury from her. Just like Villalobos 10 minutes earlier, knowing she had a hammer, did not fear serious bodily injury from her in the position on the patio that they were. Okay? And neither should he. Neither should he have. Who was emotionally captured in this event? Well, I suggest to you that's what we see here. We see that Sergeant Flores became emotionally captured by the stress of this event. Actually, he's the one that got this whole thing started by saying you can go in. He's the one that ended up feeling responsible that Salinas got hit with the candle. And he's the one that formed this rudimentary plan that put him in this position. But even from that position he was in, she did not have the opportunity to cause him serious bodily injury or death when he fired 3 shots at her. So when the justification fails, when there is no justification, then you look at the elements of the crime itself, right? And I've tried to do this with any of the people that they called as witnesses or any of the officers who testified about. What about the elements of the crime themselves? Did Officer Flores, or Detective Flores, or Sergeant Flores, did he, on or about June 23rd, 2023 in Bexar County, Texas, intentionally or knowingly cause the death of Melissa Perez? Or alternatively, did he with intent to cause serious bodily injury to Melissa Perez, did an act clearly dangerous to human life that caused the death of Melissa Perez? And they acknowledged that he did that. The state did prove that he did those things. You can see it all on the video. He wasn't shooting recklessly. He was shooting purposefully at her midsection, knowing that's an act clearly dangerous to human life, to stop her from charging, okay? He admitted to that. I think I even heard the lawyer say, we own that, right? She did. Sergeant Flores did commit the offense of murder absent the justification. Then the intent then is that caused her death. And we know it caused her death because we heard from the medical examiner who told you that the bullet Sergeant Flores fired entered her breast and lodged in her lower back, right? That was the bullet that was extracted from Sergeant Flores' gun with a downward angle. Officer Eleazar Alejandro, what evidence do we have whether or not he committed the offense of murder? Did he intentionally or knowingly cause the death of another? He did. The second bullet from the autopsy, you remember, entered under her arm, right? And exited kind of her upper back, or the middle of her back in an upward angle. If you remember that from the medical examiner. Not a downward angle, an upward angle, right? And you look at the size disparity between the two, right? Sergeant Flores' bullet's going downward. Sergeant Alejandro's bullet is going upward, okay? And then you can see from the video, from the body-worn camera, you can look at Thompson's or whatever at that precise moment where you can see the bullet blast from Officer Alejandro's gun at the time her arm was raised in precisely the same way that it had to have been for her to have been shot there. Was that an act clearly dangerous to human life of him shooting her? It was. And did it cause her death? It did. Aggravated assault by a public servant. You know, these crimes, aggravated assault, there's aggravated assault by causing bodily injury with a deadly weapon, and there's aggravated assault by threat using a deadly weapon, right? So any shot that's fired that missed, right, is still a threat to that person. And again, there's testimony of that, right? So any shot, and Alejandro fired 10 times, Flores fired 3 times, Villalobos fired 3 times, right? So any shot that they fired that missed is an aggravated assault by threat by a public servant. Any shot that struck her, in the cases of the 2 bullets that struck her, both of those bullets caused her death or murder, and that's the difference between those 2 kinds of crimes, right? Elements of deadly conduct is a lesser offense. Each one of those, murder, aggravated assault, and deadly conduct, is a lesser offense of those. And deadly conduct ignores the fact that Melissa was threatened, or it ignores the fact that she was injured, and ignores the fact that she was killed. Okay, so it's the crime of shooting into somebody's apartment, right? They normally discharge a weapon at in the direction of an individual, whether it was a threat to them or whether it struck them. It's still a crime, and that crime is deadly conduct. Okay? They did, each of them, discharge a weapon knowingly at Melissa Perez. Their statements admit as much. The videos tell you as much that they did. So you'll be given, at the end of your charge, there'll be verdict forms at the end of the charge, so that look like this. And what we believe that the evidence shows in this case here is that they committed each of those acts that either caused her death or threatened her or was deadly conduct. And that the place to sign off on that is at the bottom of the pages of each one of those verdicts for each of those offenses. No person is above the law. And there's a lot of talk about whether officers should be treated differently. We value our police officers. We value what they do. But any person who is accused of causing the death, murdering someone, it's not unusual for a warrant to issue for them that same day. Just because a person is a police officer that engages in the conduct does not mean that they have to be treated differently, that somehow they have to be put off, that the charging decision or the arrest decision has to be put off longer. Any one of us who engaged in a non-justified shooting would be arrested that day, and these officers were after 16 hours. Isn't an outrage. It is, why should officers get a break, right? I mean, these officers got more of a break than Melissa Perez did. When it first happened, before all the videos were watched, before all the statements were taken, they came in and they were given the consideration of, you come in, you submit your weapons. They did a round count on them. They did a GSR test on them. They issued them new weapons or whatever it is. This wouldn't happen to a typical citizen. But again, they waited it out until they saw the videos, and later that day, when they saw the videos, they read the statements, and the San Antonio Police Department, through its chain of command, said, "This ain't us. This isn't a justified shooting. We need to issue a warrant. We need to stand up and show that the citizens that we're not giving special treatment to police officers," and issued a warrant for him. There's nothing wrong about that. There's nothing to apologize for that. We've been subject to a lot of abuse, myself and Mr. Harris here, and the unit, the civil rights unit that Mr. Joe Gonzalez developed. The idea in having a unit like this and having your prosecutors look at these cases more carefully and approach these cases is to show sunlight or put sunlight on these cases, because the public and the community needs to know on these officer-involved shootings whether or not these are being pushed under the rug, or if they are being investigated properly and filed properly, and that the community has some kind of buy-in to it's fair. That just because San Antonio Police Department is investigating their own, is there a problem with that? Well, let's shine some sunlight on the facts so that a jury like yourselves looks and evaluates these cases and says, we get to make that decision, okay? Not the police officers, not their lawyers, not the experts funded by the union. The community gets to make that decision. They get to see all the facts. And this isn't just a testimonial case. This isn't a case that really has anything to do with testimony. It has everything to do with you can see it all from beginning to end about how it happened and the circumstances surrounding when it happened. And it's for you as a community to say, this is right or this is wrong. And if you believe, and if you reflect back on when you first watched the video, when you first came in here, that first, maybe it was the second day, right? When you kind of saw that first video, how you felt when you saw that shooting happen, okay? And I invite you to go back in there again and maybe play this out again so that you can kind of see how you felt about how wrong that was, that that woman had to die in that way, okay? That's your call, right? There's been a lot of people telling you, well, we were in a situation where there was nothing else we could do. There was a lot else they could have done. It didn't need to end this way. And you know, and your own moral compass has been called upon to decide this case. This isn't for the DA's office to decide we're going to look after and protect our police department. This isn't for the chief of police to say, I'm going to look at this, I'm just going to protect my own officers and put this in our pocket. They recognize that this is wrong. Wrong for this woman to have been killed. It's wrong for them to have shot her under these circumstances in her locked room. So that's why it's here. We make no apologies for it. I've worked as a public servant for 37 years. The last 31 of them as a prosecutor at this, a prosecutor, I guess at this office and another office. I make no apologies for bringing this case for you to decide and to look at and evaluate. And although you can say that Officer Soto could have done more, he did all that you need to see. Everything you need to see is on those videos and the forensic reports that follow. The rush to judgment, I've talked about that a lot. There's a lot of talk about that, right? Whether getting them arrested was somehow too soon. Again, any citizen who isn't a police officer, given the facts that we have, would have been arrested just as quickly, and they don't deserve necessarily to be treated special in those kind of circumstances. With great power comes great responsibility. We've all heard that, and it's very true. Everyone who testified for the defense agreed that the goal in a high risk entry is that no one gets hurt. That important goal was not prioritized in this plan, this rudimentary plan that they came up with, that Sergeant Flores was responsible for and came up with. Her safety was not a consideration. It was their safety, that is one of the considerations. Her safety was not considered in this plan. Given the resources and training of these officers, it is not reasonable for Ms. Perez to be shot in this high-stakes game of chicken that they set up for her. It was almost as if they're in a semi and they put this person on a motorcycle in direct path of them and said, let's go at it, right? That's basically what happened to her. Finding someone guilty of a crime is simply holding that person accountable, right? We ask you to hold them accountable. We ask you to tell the police department that their officers need to adhere to their training, that the officers themselves need to pay attention to their training. Mr. Harris had shown you that the policy that was going in there that they've all been trained on or so. That human life is important and it's to be protected and not to be ignored when you're confronting a situation like that. The answer is not to release a verdict that basically says, congratulations guys, pat on the back, go back to service. It can't be that. Or there's going to be many other instances, as there have been, of police officers shooting citizens unnecessarily. So Godspeed. Please return a true verdict on this case. Thank you.
All right, members of the jury, you now have all the evidence before you. You have the author of the charge of the court, and you have the closing argument of counsel. Once each of you is assembled in the jury room, you can begin your deliberations. We will be in recess until you've advised us that you've reached a verdict. I'm going to ask alternate juror 107 to stay behind. The rest of you, go ahead and instructing you to begin your deliberations.
All rise for the jury.
seated.
All right, members of the jury, welcome back. At this time, I will ask your foreperson, have you reached a verdict?
We have.
Have you reached a verdict in every case, each count?
We have.
Is every verdict unanimous?
Yes, sir.
All right, if you could hand it to the deputy, please.
Thank you, sir.
All right, cause number 2023 CR 11510A, Alejandro Flores, count 1 murder, verdict form. We, the jury, find the defendant Alfred Flores not guilty of the offense of murder as charged in count 1 of the indictment in cause number 2023 CR 11510A. Number 2, aggravated assault, verdict form. We, the jury, find the defendant Alfred Flores not guilty of the offense of aggravated assault as charged in count 2 of the indictment in cause number 2023 CR 11510A. Number 3, aggravated assault, verdict form. We, the jury, find the defendant Alfred Flores not guilty of the offense of aggravated assault as charged in count 3 of the indictment in cause number 2023 CR 11510A. Number 4, deadly conduct, verdict form. We, the jury, find the defendant Alfred Flores not guilty of the offense of deadly conduct as charged in count 4 of the indictment in cause number 2023 CR 11510A. Cause number 2023 CR 11510B, count 1 murder for Eleazar Alejandro, verdict form. We, the jury, find the defendant Eleazar Alejandro not guilty of the offense of murder as charged in count 1 of the indictment and cause number 2023 CR 11510B. Count 2, aggravated assault, verdict form. We, the jury, find the defendant Eleazar Alejandro not guilty of the offense of aggravated assault as charged in count 2 of the indictment and cause number 2023 CR 11510B. Count 3, aggravated assault, verdict form. We, the jury, find the defendant Eleazar Alejandro not guilty of the offense of aggravated assault as charged in count 3 of the indictment and cause number 2023 CR 11510B. Count 4, deadly conduct, verdict form. We, the jury, find the defendant Eleazar Alejandro not guilty of the offense of deadly conduct as charged in count 4 of the indictment and cause number 2023 CR 11510B. Cause number 2023 CR 11510C, Nathaniel Villalobos, count 1, aggravated assault, verdict form. We, the jury, find the defendant Nathaniel Villalobos not guilty of the offense of aggravated assault as charged in count 1 of the indictment and cause number 2023 CR 11510C. Count 2, deadly conduct, verdict form. We, the jury, find the defendant Nathaniel Villalobos not guilty of the offense of deadly conduct as charged in count 2 of the indictment and cause number 2023 CR 11510C. Does either side wish to have the jury polled?
No, Judge, we don't wish to.
No, Your Honor.
All right, members of the jury, what that means, the court finds that your verdict is unanimous verdict on each verdict for each defendant. Y'all may have a seat. With that, I'm going to go ahead and release you from your jury service. Your jury service is now complete. After I swore you in, I gave you some instructions. Those instructions included you not doing any sort of independent investigation, not talking about this case with anyone at all. All the things that I instructed you not to do, you are now released from each and every one of those instructions. That means if you choose to look up anything, do any sort of independent research, if you choose to talk to anybody about this case, you're welcome to do that. The choice is completely up to you. The notes that you have, those notes belong to you. When we go to the back, I'll let you take those out of the notepads. So we'll keep the pads, you keep the notes, and obviously the pens are yours to keep as well. I know that when we started this trial a very long time ago, it seems like, we kept you longer than probably any other jury that I've been involved in. And you were very positive back then. You were very gracious. I noticed during the trial you were always attentive, paying attention, making sure you were focused. You were very respectful to the court. For that and for the service that you provided as a juror, we will always be grateful to you. In a few minutes, I'm going to go to the back. I'm going to thank you personally for the service that you've done. So at this time, I'm going to go ahead and release you. You are excused.
All right for the jury? You may be seated.
The deputy advised me that the jury wanted the family to know that they were very sorry for their loss. And you guys know that you have 30 days from today's date to file expunctions. All right. Anything else before we go off the record? Anything else? All right. We're adjourned.
Yeah. I'll go back there. Okay. Yeah, that's the very
Thank you for everything you began.
Good afternoon. I'm Myra Arthur, coming to you on our live stream platforms here with breaking news this afternoon. In the last 10 to 15 minutes, we have just learned that 3 former SAPD officers have been found not guilty on all counts. This was a trial that has been going on for the last 4 weeks. These 3 former officers on trial for the shooting and killing of a woman named Melissa Perez. She was shot and killed inside her apartment in June of 2023. Taking a look live inside the courtroom here, you can see relief, reaction from those 3 defendants, their defense team, their friends, their family. There were tears in eyes as this was being read by the judge. These 3 officers were all fired from SAPD and arrested not long after that shooting in June of 2023. 2 of the 3 officers were facing charges of murder. All were facing charges of aggravated assault and deadly conduct. Again, not guilty on every single charge that these 3 defendants faced. Alfred, Flores, Nathaniel, Villalobos, Eleazar Alejandro, all found not guilty. The jury started deliberating this afternoon. That deliberation lasted less than an hour and a half before this jury came back with their unanimous verdict. So here is a little bit of background on this case. Again, as I mentioned, a woman named Melissa Perez was shot by San Antonio police in June of 2023 in her apartment. She was said to be having a mental health crisis that night. She had reportedly cut the fire alarm to the apartment. Firefighters responded, many other first responders, many officers as well. She also had a hammer in her hand at one point, trying to, while she was interacting with these officers. There was no question that the officers shot and killed Melissa Perez that night. The question at the center of this trial was whether they violated protocol in doing so. Did they violate what they were supposed to be doing, how they should have handled a call like that, of that nature, that night in June of 2023. So again, as we're looking here live inside the courtroom, people wiping away tears, obvious relief, and the beginning of a new chapter for these 3 former officers that were fired from the department after this shooting. Again, all 3 found not guilty. Our Erica Hernandez has been there covering this from day one. We're getting reaction right now. We're hoping to hear from Erica as soon as we can. This obviously a big blow for the Bexar County District Attorney's Office, not getting any guilty verdicts. And what was unique about this case was it was 3 people all charged at once. 3 people with their 3 defense teams, obviously working in conjunction. But this was a case that was so long, lasted nearly a month, and at times the testimony was tedious. But there were also times when the defense, we watched here on our live stream, as well as many of you watched, the defense had questions
said that the decision was made
about the prosecution's case. Let's listen in here.
To charge these officers without a thorough review. I don't know if you will take a look at the user audit trails, but none of the command staff looked at any of the videos. So how can they make a decision to charge these officers if they didn't look at the videos and they didn't do a thorough investigation? And this is shameful. I would hope that city council, city manager does something about this institutional failure, and it's unconscionable. It never should have happened.
How are the defendants, or now not defendants, doing after just hearing that not guilty?
Well, I can only speak for my client. He was extremely relieved and he was elated, and I can understand why he's grateful.
What's next for them?
There are many remedies that are available for these individuals, and we're going to have to explore them carefully.
What do you mean remedies?
Well, there are remedies at law, and I'm not going to go into them at this time.
Potential like civil action?
I'm not going to go into them at this time, but there are potential remedies for a malicious prosecution, a prosecution based on a lack of probable cause, and we're going to have to explore those.
What do you hope these remedies, whatever they might be, whatever fashion they send a message?
We'll address that when we pursue them.
Thank you, Ben.
Thank you.
Yeah, that's fine.
All right, that was Ben Cifuentes, one of the defense attorneys. Here is Nico LaHood. Many of you know him as the former district attorney here in Bexar County. He was also part of this defense team representing one of these three ex-officers on trial. Our Erica Hernandez will get a chance to speak with him momentarily. You can imagine everybody who is representing each one of these three officers, former officers, would like to weigh in on this case. It's one that you could tell they felt passionately about, and as I mentioned earlier, had big questions about the prosecution and the evidence that the prosecution brought in this case.
Thank you, man.
You also heard earlier, as we're waiting for everyone to get in position here, Ben Cifuentes, one of the attorneys, talking about action taken after this case on behalf of the men that they represented.
I mean, we knew what the truth was, but you never know until the verdict comes back, and it was a group effort, all the lawyers with us and behind me and families and a lot of hard work. I mean, the 4.5 weeks in trial is just the performance. Obviously, the preparation time and all the research done before that is the key, including our paralegals, our staff. I mean, we're just very grateful. The family are very grateful. They believed in the truth. They believed in their family members, but until that verdict comes back, it doesn't matter. So we're very grateful. They're grateful to God, and they're grateful for our efforts, and we're grateful for the opportunity that they trusted their lives in us.
Were you shocked how quickly they came up back with the verdict?
I mean, you never know what a jury's going to do. We asked for a quick verdict. I mean, we were very deliberate about that. I mean, the 4.5 weeks, and they paid attention to everything. They wrote a lot of notes. We were very specific about it. So with a verdict, you never know. But we asked for a quick verdict, and we're glad that it came back quickly.
Y'all made a lot of references during, and especially in closing, how y'all were all former prosecutors. What is your take on the case that they presented?
It should have never gone forward. I mean, not just our opinions, but the opinions of the experts that normally testify for the government said the same thing. This was unfortunate. I mean, I think the case and the evidence spoke for itself. The government had no expert witnesses, and their theory kept shifting throughout the trial, and we're just grateful that the jury saw it.
So what happens now?
A little relief. We can sleep now. We're going to try to sleep. We're going to try to sleep. The families are overjoyed. Bug, his wife, is expecting their first baby. I think Nathan's going to work on another baby. I mean, they're very grateful. Their family can move forward now.
There was fighting for their jobs back.
That's going to leave that to them. I mean, there's some mixed reviews in there, but I'll let them make that decision as time goes on.
How are they doing?
Relieved, grateful. I mean, they're so. I mean, it was a neat experience. It's something different. There's more pressure when you actually care about your clients. You really like them, and we really liked all of them, and it was a good synergy between us all. And so, they're great.
Do your clients have anything to say? They want to say anything right now?
They may. We'll ask them. I mean, I'm not sure. They're just enjoying the moment.
There was testimony in this trial that suggested that Police Chief McManus had faced political pressure to bring these charges towards these officers. Is that also your position? What do you think about that?
Well, I think, look, I wasn't in the meeting. All I know, there was a meeting for the brass, and in 6.5 hours, you cannot make a determination on whether 3 individuals should be charged with murder. You haven't even looked. I think Mr. Cifuentes brought out in his questioning that the audit trails show who watched videos and who didn't, and it was impossible to do the investigation needed to walk warrants on officers, and it wasn't done. And so those are a directive in 6.5 hours. It made it to a captain. Captain made it to the Detective Soto, and then we walked those warrants. So, I mean, you can do the math yourself.
Now, what does this trial shine light on?
To do what's right, not what's easy. I mean, something may look awful, but it doesn't mean it's unlawful, as we said during the trial. I mean, just pause, wait, These are not puppets, these are people, and this is not a political theater, and so we don't succumb to that. And so I just pray courage over our leaders in this community to do the right thing. Don't do what's easy, do what's right.
I know Tom had a very emotional interaction with the family during closing. Anything to say to the Perez family?
Oh, I mean, I've experienced loss with my brother passing away under very different circumstances than this, but loss is loss, and so we feel for them. I mean, it was never about them. It was never against them. They went through a lot too, unfortunately, with Ms. Perez. They were very gracious. I mean, Ms. Nieto was gracious when she testified. Her daughter, Alexis, is a blessing to her brother, Dylan, and so we wish them well. I mean, I personally will be praying for them, but we wish them well.
Anyone else want to say? Anybody else?
Nigel LaHood there, one of the many defense attorneys, part of this defense of all three of these men here.
Sure. I think I said everything in close on behalf of Alfred and these officers. Nothing brings their loved one back, and this is a tragedy, and we're sorry about that. But we're happy the jury found the right decision and made to the right place. Everybody can go home with some closure. Thank you.
Thank you. Thank you.
Really, the tone from each of these defense attorneys that we heard from was that they believe this is a case that never should have gone forward. There were questions throughout the entire trial about which investigators had reviewed which hours of body camera video, some admitting on the stand that they had not watched the entire thing. That was a big question that the defense had, really kind of hammering in on some of the evidence the prosecution brought forward, which of course is the case in any trial. But in this trial, there were at least two instances when the defense said the prosecution brought forth evidence that they were unaware of, which in any trial, a prosecution is supposed to notify the defense team, this is what we have against your client, this is the evidence that we are using to prosecute them. There were big questions that really brought the trial to a standstill at least one time for that very issue. We did get a statement from the Bexar County DA's office in regard to all of these not guilty verdicts in the past few minutes here. The DA's office simply saying they respect the jury's decision and they have no further comment at this time. If you are just joining us, this is a verdict of not guilty on all charges for three former SAPD officers who shot and killed a woman back in 2023. We want to take you back into the courtroom for that moment that the verdict was read by Judge Ron Howell. Take a listen.
Alejandro Flores, count 1 murder, verdict form. We, the jury, find the defendant, Alfred Flores, not guilty of the offense of murder as charged in count 1 of the indictment in cause number 2023 CR 11510A. Number 2, aggravated assault, verdict form. We, the jury, find the defendant, Alfred Flores, not guilty of the offense of aggravated assault as charged in count 2 of the indictment in cause number 2023 CR 11510A. Number 3, aggravated assault, verdict form. We, the jury, find the defendant, Alfred Flores, not guilty of the offense of aggravated assault as charged in count 3 of the indictment in cause number 2023 CR 11510A. Number 4, deadly conduct, verdict form. We, the jury, find the defendant, Alfred Flores, not guilty of the offense of deadly conduct as charged in count 4 of the indictment in cause number 2023 CR 11510A. Cause number 2023 CR 11510B, count 1 murder for Eleazar Alejandro, verdict form. We, the jury, find the defendant, Eleazar Alejandro, not guilty of the offense of murder as charged in count 1 of the indictment and cause number 2023 CR 11510B. Count 2, aggravated assault, verdict form. We, the jury, find the defendant, Eleazar Alejandro, not guilty of the offense of aggravated assault as charged in count 2 of the indictment in cause number 2023 CR 11510B. Count 3, aggravated assault, verdict form. We, the jury, find the defendant, Eleazar Alejandro, not guilty of the offense of aggravated assault as charged in count 3 of the indictment in cause number 2023 CR 11510B. Count 4, deadly conduct, verdict form. We, the jury, find the defendant, Eleazar Alejandro, not guilty of the offense of deadly conduct as charged in count 4 of the indictment in cause number 2023 CR 11510B. Cause number 2023 CR 11510C, Nathaniel Villalobos. Count 1, aggravated assault, verdict form. We, the jury, find the defendant, Nathaniel Villalobos, not guilty of the offense of aggravated assault as charged in count 1 of the indictment in cause number 2023 CR 11510C. Count 2, deadly conduct, verdict form. We, the jury, find the defendant, Nathaniel Villalobos, not guilty of the offense of deadly conduct as charged in count 2 of the indictment in cause number 2023 CR 11510C. Does either side wish to have the jury polled?
No, Judge, we don't wish to.
No, Your Honor. No, Your Honor. No, Your Honor.
All right, members of the jury, what that means, the court finds that your verdict is unanimous verdict on each verdict for each defendant. Y'all may have a seat.
Nathaniel Villalobos, Alfred Flores, Eleazar Alejandro will walk out of the Bexar County Courthouse today, found not guilty on charges of murder, aggravated assault, and deadly conduct. Our Erica Hernandez, as I mentioned, has been in this courtroom covering this trial for the last 4 weeks or so. She is standing by as we're going to talk with her about what this means, what could be next in this case, if anything, and what does this mean for the DA's office for such a huge case to go down with not guilty verdicts for every single one of the defendants. We're going to talk to her on the other side of a very quick 1-minute break. We'll be right back. Welcome back to breaking news coverage here on our KSAT streaming platforms this afternoon. We are now about 30 minutes out from the not guilty verdicts for 3 former SAPD officers who have been in a very lengthy trial for nearly a month now. Our Erica Hernandez has been a huge part of our coverage for that trial, and she has been catching up with folks, getting their reaction there in and outside of the courtroom. I want to go now live to Erica, who is at the Bexar County Courthouse. Erica, these 3 officers, former officers now, Alfred Flores, Nathaniel Villalobos, Eleazar Alejandro, all hearing not guilty for every count that they faced. We could see a bit of it, but tell us a little bit about the reaction, that moment when the verdict was read in the courtroom.
Yeah, so Myra, inside the courtroom at that time, there was a lot of emotion. You kind of heard a relief exhale from the defense side, and there was a lot of tears on the side of Melissa Perez's family. Her daughter broke down multiple occasions while those verdicts were being read. That's right, like you just said, it was not guilty across the board on all charges for all 3 former officers. After that verdict was read, the state whisked the family out, and they were out the door as well. That there's not much else that we could get from the state right now. We reached out to the district attorney's office, and they told us the Bexar County District Attorney's Office respects the jury's verdict and has no further comment. I think at some point, though, that DA's office is going to have to answer some questions about this case and how it was handled, Myra.
Yeah, Erica, you make a really good point. We're obviously so focused right now on these 3 men being found not guilty, but there is a family at the center of this who has experienced tremendous loss, Melissa Perez's family. And I know that you'll make every effort to try to catch up with them to see how they are doing after the reading of those verdicts. You mentioned the DA's office. There were big questions during this trial about the evidence against these 3 former officers and how the prosecution was handling that. You have covered the DA's office extensively, covered the courthouse for years. What do you think having all 3 of these men found not guilty means for the DA's office? What kind of impact does that have?
I think it's a big impact, Myra. We've kind of seen a big blow to the DA's office. And you had all these defense attorneys who were former prosecutors, Nico LaHood himself, a former district attorney, and all of them saying that this was a very rushed investigation, almost politically motivated in closing arguments is how they kind of described it. Within 4 hours, they said that a decision was made from higher ups to charge these 3 now former officers with those big charges. I mean, 2 of them were facing murder, 1 aggravated assault by a public servant, which is also just a first degree. So there are some really big implications here, and I think it's really interesting that the DA's office doesn't want to answer those questions just yet. We saw actually District Attorney Joe Gonzalez only twice during this entire trial, one on the first day during opening arguments and a little bit today during closing arguments, but nothing really in between. I think he needs to answer some of these questions as well. I know afterwards one of the defense attorneys, Ben Fuentes, even kind of indicating that these former officers could be seeking some kind of civil lawsuit on the way this case was prosecuted. So it'll be really interesting to see what kind of comes of this. And I think we, not only have to hear from the district attorney, but also from SAPD Chief William McManus, who was implicated a lot in this case as well, and allowing these charges to move forward. So still a lot of unanswered questions, Myra. So it will be interesting to see how this plays out in the coming days.
Yeah, Erica, there has been so much strife between SAPD and the current DA's office about the way investigations are handled, really on both ends. You mentioned the tone that was struck in closing arguments. Do you think that there were some really standout, sort of decisive moments in this trial that you can point to where you felt like the defense really nailed the prosecution in terms of questioning the evidence against their clients?
I think there's a few of those moments, actually, Myra. If you kind of go back to the first few days of when this trial started, one of those first officers that was at the scene was Jonathan Salinas. He was a state witness that was called up. And to hear him testify that he didn't agree with their theory after Perez had swung a hammer at him, they said basically to him she was justified in doing so, and he didn't agree with that. He even said how he was upset by that during pretrial motions when he was told that by the state. And at that point, he almost became a defense witness and ended up pleading the fifth and not testifying any longer. I think that was a big turning point in this case when we kind of started to see things go downhill. Another thing, the state had up to 4 expert witnesses to testify on their behalf. 3 of them were not allowed to testify because they didn't have the proper qualifications. And one of them, the 4th one, actually turned his theory around and was more siding with the defense's side. So I think that's really big when you don't have any expert witness to testify on your behalf on why you're prosecuting and why you believe this shooting was not justified. But as for the defense, they had former detectives who were at the department at the time of the shooting who were like, we would have never taken this case up for charges, and we never thought. I want to go back to Detective Mark Duke, who said he's always been an attorney for the state, and he never thought he'd be testifying for the defense in a case, and here he was testifying on behalf of the defense. So there was a lot of interesting up and downs. We saw a lot of arguments and a lot of back and forth, a lot of jabs. There was a lot of emotion, a lot of drama to this. But I think in the end, the jury made up their mind because they only came back in just a little over an hour and a half when we thought we could be here for hours today, Myra.
Yeah, several points there, like you said, Erica, where it seemed like someone would be testifying on the behalf of the prosecution to make their case. And really, the words that they said seemed to align much more with what the defense was trying to prove in this case. And I do remember when this shooting happened in June of 2023, so often when there is a shooting involving a police officer, it takes a while for us, for the public, to get an idea of really what happened. But this transpired very quickly in terms of the police chief saying, this is what we believe happened that night. Melissa Perez was having a mental health crisis, and then later the firing of these 3 men. Do I have that right?
That is correct. The actual firing of the 3 men happened a few months later, I believe. But yeah, it was 16 hours after the shooting had happened that it was announced that the 3 men were actually going to be charged with murder. That ended up being indicted a little differently, where one didn't face a murder charge. But yeah, and then within the testimony that we heard, especially when the defense, that decision may have been made up to 4 hours. We heard from the lead detective, Sota, on the case and the defense grilled him. He admitted that there was mistakes made, that he made mistakes in how he assessed, that he didn't even look at all the body camera footage before that decision was made. So there's still so many inconsistencies on the state's case that, I think the DA and maybe the SAPD need to answer about. So like I said a little earlier, I think we need to hear from them at some point to explain why this case was presented, because not even 12 jurors barely deliberated for less than 2 hours to come up with not guilty across the board.
Yeah, roughly an hour and a half of deliberations, and the verdict we heard there from Judge Ron Hell, unanimous. Erica, I appreciate your coverage of this and your insight. I know it's a breaking news situation. It's hectic trying to find people, talk to them, and then turn it around here. So I appreciate you doing that for us. Of course, we're going to have more of this not guilty verdict for all 3 of these former SAPD officers coming up today at 5 o'clock on the news at 6, as well as the Night Beat. And remember, you can check us out right here on our streaming platforms, ksat.com and KSAT Plus, anytime for the latest on this. But again, a trial that has lasted nearly a month and had so much back and forth, at times very tedious testimony about what happened the night that a woman, Melissa Perez, was shot and killed in June of 2023. 3 former SAPD officers fired soon after, charged with murder, aggravated assault, and deadly conduct. All 3 of those men found not guilty this afternoon in a unanimous verdict from a Bexar County jury. We're going to sign off here on our streaming platforms. We'll see you on the news at 5.